Good morning once again. And if you have not yet completed the pre-training survey, please do so now. You will see a link to the pre-training survey pinned in the chat. So please take a few minutes as we start to do that. And there will also be a post-training survey. And as mentioned, this is a requirement by the Law Council. And so please be sure to do this, and especially if you are planning to earn CLE points for your attendance of this training. My name is Lynette Toy, and I'm the Research and Fundraising Manager at FIDA Uganda. I also manage the FIDA Leadership Academy. So today's training is the third of our 2024 CLE training series under the FIDA Leadership Academy. And so we rolled out our first CLE training series in July of 2023 and presented 8 trainings over the course of that year. FIDA Uganda, as a professional membership organization, is charged with the responsibility to promote the professional development of female lawyers through training, mentorship, capacity building, creating networking opportunities, and convening policy advisory spaces to enhance access to justice and women's empowerment. In pursuit of this responsibility, FIDA Uganda launched the Leadership Academy in 2022. This academy draws on the organization's 50 years of existence and leverages our membership's wealth of experience from the diverse positions that they occupy to propagate knowledge and best practices among female lawyers in Uganda. FIDA Uganda, through our Leadership Academy, is accredited by the Uganda Law Council as a provider of continuing legal education and offers CLE courses to train legal practitioners on gender-responsive legal aid service provision, feminist lawyering, and the application of regional and international instruments to advance gender-responsive litigation. All of our CLE courses are led by experts in their respective fields, including accomplished attorneys, legal scholars, and industry specialists. Today's training will be co-facilitated by 2 trainers who bring complementary expertise to the table. Thomas Kyokuhaire is an expert in development and disability rights and has served as the Country Director of Action for Development and Disability, that is ADD International, in Uganda. Previously, he has worked as a project manager and advisor with War Child Holland, ZOA Netherlands, and Danida. Mr. Kyokuhaire holds a BSc and MBA from the Uganda Technology and Management University in Uganda. Mr. Kyokuhaire has also been an integral part of FIDA Uganda's growth towards becoming a more inclusive service provider of services to persons with disabilities. And so, Thomas, we are very grateful that you're with us today, and thank you for once again bringing your expertise on board for this training. Our second trainer is Dr. Patricia Atim and who holds a PhD in disability studies from the University of Cape Town and an LLM in human rights and democratization from the University of Pretoria in South Africa. She is currently an assistant lecturer at the School of Law, Makerere University, and is attached to the Department of Public and Comparative Law. And she is also currently the head of the Legal Aid Unit in the Public Interest Litigation Clinic. And this is a project of the School of Law at Makerere University. In her current role, she leads the team in the provision of legal aid services to marginalized persons. And we have selected the issue of disability inclusion and rights for this CLE training, and because we know that approximately 2.5% of Uganda's population live with a disability, and there are more women than men living with disabilities in the country. We also know that persons with disabilities are more vulnerable to be subjected to gender-based violence than the general population, and that they face additional barriers in seeking redress and accessing justice. As FIDA Uganda, we recognize the fact that women with disabilities cannot adequately be served and supported in pursuit of the realization of their rights in the absence of specialized and inclusive services and dedicated programming. We have therefore selected this training topic to enable practitioners, specifically those working in the NGO sector and in legal aid service provision, to increase their capacity in providing inclusive services. So as we are about to start, I'd like to share with you the program for today. I will do a quick rundown of this program so that you know what to expect. And I will also share a link where you can access the program throughout the day. Though I know that those who have registered before the start of this training would have received the program over email. Okay. And so, is our son on? Can I speak? Yeah. Thank you. And so, a quick rundown of our program. So we have completed the pre-training survey and our facilitators and our training have been welcomed. And so our first session will be led by Mr. Thomas Kyokuhaire. And this session will really look at disability inclusion as a comprehensive way of introduction. And you'll see the few sub-headings that Thomas will cover, and among other elements of what it really means to have to be disability inclusive. And after this 2-hour session, we will have a short break. And the second session will be led by Dr. Patricia Atim. And this session will focus on the legal framework protecting the rights of persons with disabilities and ensuring justice to all. And she will also cover the guidelines of PILAC or legal and in managing cases of persons with disabilities in court, and which is very important to practitioners who represent persons with disabilities. We will then have another short break. And our third session for the day will once again be facilitated by Mr. Thomas Kyokuhaire, that will specifically look at equipping lawyers practically to provide inclusive services to persons with disabilities. And this includes safeguarding and the appropriate management of cases of clients who face sexual and gender-based violence. And so that is an overview of our training for the day. And at this point, I would like to hand over to Mr. Thomas Kyokuhaire to lead the first session for us. And so, Thomas, you're very, very welcome.
Thank you so much, Lynette. Good morning, everyone. Can I check if you're hearing me well? A thumbs up or something? Good. Yeah, I think Lynette has given the background that we work in society which has a number of people, all kinds of people. In Uganda, there are people who have been left out for a very long time, not only in Uganda, but wherever we work. And one of such, people, especially in the legal fraternity and those working in the human rights area, the objective is to make sure that you support the vulnerable. And persons with disabilities are that kind of vulnerable group. And women and girls suffer even more vulnerability. But yet, we are doing a lot of things, and yet we find that some of those people are not benefiting from that. So the task today is for us, first of all, look at what we understand by disability and how we can make our work more effective. By effective, I mean, can I request to be allowed to share my screen? Maybe FIDA Uganda can stop. Lynette, can I share my screen, please? I have a presentation. It's right here.
Yes, yes, that's fine, Thomas. Yes.
Just confirm that you can see my screen.
Not yet.
Sorry?
Not yet.
So we are going to get introduced to disability and disability inclusion. And I think this is where I want to start. You realize that I'm putting disability inclusion in brackets. Many times we make a mistake of thinking that we are making adjustments, or we are making our workspaces or even our services accessible, and we forget ourselves. But when we make work inclusive, it's not only inclusive of persons with disabilities, but it is inclusive of everyone. And I usually give this example that when technology was coming up with the lifts in buildings, those lifts were meant to be for persons with disabilities. But you find even young people also scrambling to take a lift and not to take stairs. So the point is that when we make our services inclusive, we shouldn't only have in mind that we're doing it for persons with disabilities, but well, can I confirm that you're seeing the screen? Sorry, it looks like I'm not getting feedback.
Thomas, we can see your screen.
Okay, thank you. Yeah, so we want to find the definition of disability. Many of us, I'm sure, have come across a person with a disability or people with disabilities. And we need to check whether we are all at the same level of understanding what a disability is. First of all, many of us confuse an impairment with a disability. A person might have an impairment. For instance, a limb it may not have a limb, or might not have vision, or might not have hearing, that is an impairment. So, but that person doesn't mean that he's disabled. So in terms of defining disability, we put a clear separation between an impairment and a disability. Then, but for us to understand disability, we need to talk about barriers. So if we have a mix of an impairment and a barrier, then that makes it a disability. What do I mean here? For instance, I might be using a wheelchair and I can move wherever I want to go without a problem. But if I have to take stairs, then the stairs make me disabled. If I have to, I have a visual impairment and I can't see, but I know how to read and write using my technology. If I get someplace and that technology is not available, that means that, or even the font is too small, then that barrier makes my impairment disabled. So there's a very definition is mainly around barriers. And the task we have as service providers is not to mind about an impairment, because we have no control over impairments. And impairments can come at birth. Impairments can be acquired later on in life. But barriers, as practitioners, as service providers, we have control and there's something that we can do around removing or mitigating the effect of barriers. So the definition and understanding of disability has changed over time. From at first, everybody thought a disability is a medical issue. That's why you will see, you would hear that people, most of the disability work was around medicine, physiotherapy, we'll talk about all this, and very few people were really thinking about the disability outside the medical area. Then it came to charity model, where we found that everybody would look at a person with disabilities, they would look at that person with pity. And therefore, all the charity organizations, all the charitable work we are doing would look at disability as, people that need to be pitied. And that's why you see, even some people would say, okay, I'm doing this for the good of humanity or for this. But from now, we want to think about disability not from a charity model, but rather from a social model or from a human rights model. The social model means that we understand disability from society, that people like any one of us are born and raised in communities. So it is the society that enables us. It's like you growing up in a family. If the family takes care of you, or if the family chooses not to take care of you, then your growth is affected. So the social model looks at, society as playing a very big role in creating the barriers, but also in removing the barriers, and or even in mitigating the impact of the barriers on the impairments. So, but now the latest understanding of disability is the functionality model or the functional model. I'm sure many of you who participated in the recent census, they must have asked you about your functionality, whether you're seeing properly or even with the glasses or without glasses, or whether you're hearing or whether, so it's about the function, not necessarily the impairment. I might have a hearing impairment, but I may not be deaf. So the importance of this is that a person might have an impairment, but you need to check what kind of impairment it is. I might have a visual impairment, but when I put on my glasses, then I can see. If I put in my hearing aids, I can see. If I have a walking stick, or if I have a wheelchair, I can move. So it's about the functional of a person. So the definition is, first of all, it's a long-term physical, mental, intellectual, or sensory impairment. And here the key word is long-term. For instance, a person might have a fracture, and then that fracture is corrected. So a person might have clutches for a month or 2 months, and then it's corrected, so it doesn't become an impairment. A person might have a visual impairment, or an eye disease, and it goes, or cataract, for instance, it goes to hospital, they correct it, and it becomes okay. So, so that doesn't fall under the definition of disability. So the whole thing is about long term. Then the second thing that we need to look at is the interaction with the environment, attitude, and institutional barriers. So that interaction between the impairment and environment, attitude, and institutional barriers that prevent full and effective participation. The ultimate objective of this kind of work is ensuring that every person has an equal right to effectively participate in society. So the definition is around long-term impairment, whether it is physical, mental, intellectual, sensory, and there's that interaction with a barrier, whether that barrier is environmental, whether it is attitudinal, whether it is institutional. And that barrier should be preventing full and effective participation in society. So as service providers, our control, things that are within our control that we can work around is promoting participation, but also working around reducing the barriers. So, but now this definition is for looking at the rights-based approach to disability. When we look at the functional definition, the definition around the functional model is that it is that interaction with a functional limitation. Here it is about, there you're looking at but here it is about functional limitation. I could have loved to have a meeting with the CEO, but the stairs have stopped me from getting there. So the functional limitation. But if I got a lift, that means even if the meeting is upstairs, still I can go. If there's a group meeting and you're speaking English and I can't speak English, that means I'm limited in terms of understanding. If you're speaking slowly or silently and you're not loud enough and I have a hearing impairment, that means I have that functional limitation in hearing. Again, the whole thing is about participation in society. Now, there are types of disabilities, but impairments in this case, and in Uganda, these are, they can be found on the Schedule 3 of the Persons with Disabilities Act of 2020. And some of these include physical disability. I'm sure many of you have seen people with physical disability, but the physical disability also are in different categories. There are those physical disabilities that are brought about by cerebral palsy. I'm sure you've seen people who have difficulty in talking, people who have difficulty in walking, people who have difficulty in speech, brought about by cerebral palsy. There are those who don't have limbs, but yet the other parts are functioning well. There are those who are paralyzed, and there are those who are deformed right from birth. And I think many of us have come across this because these ones are visible. We have the impairments that are visible, and many of the impairments are the most problematic ones are not visible. We have the hearing disability. Again, here we have two categories. There are those who are totally deaf, who can't hear at all, and there are those who are hard of hearing. And the difference here, why this is important for us in programs, but also in people in service provision, if I come across a deaf person, when I'm planning to provide a service to that person, the barriers are different from the hard of hearing person. For instance, a deaf person, I'll need a sign language interpreter, or I'll need translation, or I need, somebody to write transcription. But if it is hard of hearing, I only perhaps need to speak louder. I'll perhaps allow that person to sit in front. I would allow that person to, when the person is staring at me, because most of these people can read lips. So, in other words, the definition, the understanding the different categories help you on how to organize your service provision. Then we have the visual disability, including blind and those low vision disability. I'm sure you've come across people who can't see at all. So that means for those ones, you need to ask yourself, if I'm to provide legal aid clinic, if I'm organizing a legal aid clinic and there are deaf people and there are blind people there, what do I need to do? If I have a low vision person, the ones that most of you call the nose readers, the ones that you see drawing the reading the book close to the eyes, then you know what to do. So the visual disability is at that line between blindness, between low vision and blindness. Then we have deaf and blind. Here we have those who are deaf, but we have those, or you might come across those who have visual disability, but you may also have who have both deaf and blind, and these are common. Most of the people who are left behind are deaf and blind kind of disability, because now these are have a problem. Then we have mental disability, including psychiatric disability, and then learning disability. Again, both of these kinds of disabilities are all under the mental disability. Again, the psychiatric, I'm sure many of you want to call these people mad, but the language is psychiatric disability. They are not mad. And then there are those who have learning disability, and I'm sure many of us have come across these people whom teachers call slow learners. A person might take long to learn, or might need some assistance to learn. So instead of saying that the person is stupid or the person is right, but the correct understanding would be a learning disability. Then we have albinism. I'm sure many of you have come across people with albinism. Again, a person might ask, is really albinism a disability? Yes, it is, because the impairment there is around the skin, the pigmentation of the skin. And again, when you understand their barriers, you'll be able to plan for them. For instance, when you find we've come across situations in schools where parents have been denied to take their children to school because the school uniform is short-sleeved, and yet a child with an albinism will want a long-sleeved shirt and a long-sleeved trouser. We've come across organizations that have corporate wear, and say our corporate wear is a t-shirt or this kind of shirt which is short-sleeved. But now, if you have an employee with albinism, or if you have a respondent with albinism, for him or her wants to put on long sleeve, and wants to put on glasses, wants to put on a wide-brimmed hat. So again, understanding that disability will enable you to know how to handle, to deal with that kind of thing. Then we have the little people. These are, some of you call them the pygmies, but again, if you don't want to disrespect them, you can call them people of short stature. Then we have people with multiple disability. You might find a person who is little but with albinism and with a mental disability or psychiatric disability, and you find that the people that we know but are not yet in our law books. I'm sure many of you have come across autism, people with autism. Especially the children, and many parents are struggling with how to deal with autistic children. Many of them say that they are stubborn, they are destructive, they are what, but it's a matter of understanding that kind of disability and being able to deal with it. We have vitiligo. I don't know how many of you have come across people with vitiligo. Again, this is still not yet recognized within our within that schedule. So again, you might find that a person with vitiligo has also some barriers to participating in society. There are other disabilities like epilepsy, which are not mentioned, and there's discussion whether epilepsy is a disability or not. But since, again, the question there is it long-term? Is it impairing a person from participating in society activities, or is it, does that person find a barrier? And one of the barriers in organizations, for instance, person with the epilepsy will need to take time off when it is a period for attack, or when that person needs to do regular checkup, that person needs to take medication on a regular basis. But if a person is employed, or if a person is in an organization that doesn't allow people to get off, to take medical leave, or that is not planned, then you find that that becomes a barrier to that person. Then we come to the question, why a person with disabilities not seeking, actually the word is not seeking our services. The word missing there is not seeking. Or what is preventing persons with disabilities from accessing justice? Again, well, I talked about the barriers. We have a number of barriers that we shall go through. Again, when we are looking at this, I want you to think about whether you're providing a legal aid clinic, whether the access to justice is about accessing a lawyer, or legal services, or that person is accessing Christians, or that person is getting to correctional centers like prisons. So you find that there are those barriers, and one of which is the infrastructure barriers. Think of that person with a disability coming from Katanga, and is, let me use the word you people could easily understand, crawling. The person has no wheelchair, the person has no clutch or wheelchair, and the person is crawling, and the person has been abused. So the person has to move from Katanga to go to feeder off, and it has rained. Think of the taxi that is going to take. Think of a border who is going to accept that to carry that person, and think about the cost that comes with being a person with disability when it comes to infrastructure barriers. Think of Kampala. If a person has to cross from Kampala Road to the High Court, crossing the road, the street lights, the zebra crossing. Think about how people are driving their Subarus on zebra crossing. Think about how borders are crisscrossing, and the person is on a wheelchair or is using a white cane. Think about, the kind of taxis or buses that people are taking. If a person is a little person, and that person has to, jump on a border, and the border wants to go very fast. So all those are infrastructure barriers. So when you're thinking about planning a legal aid clinic at a community level, where do you plan it? Is it under mango tree? Is it in a community hall? Is it in a feeder office? I'll use feeder because they can't sue me for this. At least I know the work they are doing. So if you don't consider that there are different kind of people who have to access that premise, then that will prevent them from seeking that service. The other are the physical barriers. We've talked about coming to feeder office, and there's a requirement for checking whether I'm having a gun or not. I don't know. I don't know how they call that detector, and I'm a wheelchair. But you realize that my wheelchair can't go through because it is narrow. Think of coming to seek your service, but I have to take stairs, and yet the stairs, I can't reach there. And you can think of where you're providing your service from, and what are the physical barriers preventing a person with disability from reaching you. So it could be stairs, it could be I have to jump a trench, or I have to, cross a road. Those are the physical barriers. Then we have communication barriers. When you are announcing that there's a meeting for the legal aid clinic, you're putting it on radio. But for a person with visual or with hearing impairment, will not listen to radio. When you're putting up a poster, a flyer announcing your course on CLE, you put that poster on a notes board. A person in a wheelchair may not be able to see that poster, may not be able to read it. Or a person with vision impairment may not be able to see it. And you get a client who's coming to seek your legal services, and your contract is in font 11, yeah, and the single line or 0.5. So the person can't read the contract properly because of the font size that you're doing that. You have IEC materials with messages that carry the kind of work you're doing, or carry the kind of information you'd want people to have. But it is in a language, it is in a font, it is in a format that is not accessible to persons with disabilities. Now, I'll challenge you to think about the last material you prepared for when you're going to present to a community. Whether you provided for a sign language interpreter for people who don't hear you, or whether you thought about materials being in large font for people who have low vision, or whether you thought about Braille for people who are visually impaired, whether you thought about using multimedia for the kind of work you do. So communication barriers are also, it's like we think about, many times we think about translating from English to Ngakaramojong or from English to Luganda, but we forget to translate from this spoken to the non-spoken. Then we have the institutional barriers. When you look at some of the policies at the workplaces, you find that there are barriers in there that are preventing persons with disabilities from partaking of your services. Just think of any policy and check whether it is inclusive. Is it policy on time of arrival? If you ask me to arrive at 8 a.m. and you're asking me to clock in, but I'm using a clutch, and I'm having my colleague who is able to walk faster, and you don't give me that provision of arriving a bit later. Or is it the days of the time off, when the number of leave days, or the flexibility in terms of notifying? Because I might get a sudden attack, or I might get my disability might require, being able to have frequent checkups with the doctor, or I might require to do this or that. So those work policies, or sometimes I might get to your workplace, and all I need is to request you for a new desk, because I'm a person of short stature, or I'm one. So the question would be, does your work policy provide for that adjustment? I might require you to provide for me some software on JAWS, for instance, screen readers. What is that institutional barrier that would prevent a person with disability from accessing the service that you're providing? It could be attitudinal. I think this is one of the biggest one that most persons with disabilities are encountering, because you look at a person with a disability, you immediately you think that now this one is this kind of person. I've come across, I have a colleague, I think he works, I don't know whether Patricia has met him. He is one of the lecturers at Makerere, but is a person with a disability. So he goes to an office and immediately a person is seated at the desk, pulls out 1,000 shillings because he thinks this is a person with disability who has come to beg. Or a person with a disability comes up and says, is seeking for your legal service. Last week, actually, we were having a discussion and one person went to seek a legal service, but the lawyer was not very sure whether this person can actually afford the fees until when we showed up and said, oh, okay, then if it is people, if it is these people supporting you, then we can listen to you. So there are those attitudinal barriers on how we think about persons with disabilities when we come across them. Again, I've talked about the stereotypes and prejudices. Many of us think that persons with disabilities cannot do anything on their own. So many of us think that they cannot effectively participate in work, so we deny them jobs or development programs, or we assume that certain jobs are too difficult for persons with disabilities, and yet they also they went to school, they need this service, they need that kind of support. Many of you think that persons with disabilities are difficult to handle. Yes, sometimes they are difficult because they have quite a number of requirements, which many people think that they are demands. But also, I'm sure you've come across some persons with disabilities who are quarrelsome, who have short temper, and it's all because of of long-term discrimination that has developed this kind of personality. Many of you think that because I'm planning to have an inclusive program, then it's going to be costly and expensive. Because if you had planned your clinic and now we are telling you, please think about sign language, now that is a cost. We tell you, please do a large font, then you look at it as an extra cost. Or we do this, then or even that if you need to plan for a number of people, like planning lunch, there's this person who will come with a personal assistant. That means you have lunch for two. Then you look at that as an additional cost. So yes, it's an additional cost, but it is a necessary cost if we are to reach out to persons with disabilities with the services we provide. Social exclusion, yes, stigma is everywhere. Historical barriers, of course, many of you, I'm sure, have come across this issue that when a family has a boy and a girl, that family is likely to take the boy to school and leave a girl. And when it is a person with a disability, then the person with disability is likely not go to school. And if it is a girl with a disability, then it is even worse. So again, most of the people you come across, this is it's not their making, but it's because of the social exclusion. Many of them have not had an opportunity of, going to school. The other barrier is about many of them have low esteem and lack that confidence. Most of your locations where the services are provided, the chambers, or even offices, many of persons with disabilities fear to go there because of low esteem. Persons with disabilities will not be confident to come to a meeting. You need to convince them or to assure them that it is okay. Persons with disabilities to open up, they need to a lot of patience on part of a service provider. But if you're in a hurry, if you're in a rush, you're likely not to provide that service. That alone might leave a person with disability out. Yeah, the question would be, why should we be concerned? Why don't we do our work? And, after all, there are so many people who need to be who need our services. I'm sure you've not run short of people to serve you every day. You get a number of people that you need to serve. So the question would be, why should we be concerned? We should be concerned because these are people, they are human beings, and we undertake to do human rights to programs. So if you are a human rights activist or defender, or you work to promote human rights, then you need to think of an extra effort to promote equality. So like Lynette said, in Uganda alone, we have, in the last census, 2014, there were 12.4% of the entire population in Uganda are persons with disabilities. But we know that many of the people with disabilities were not counted because of the way the data was being collected, because of many of the parents normally hide children with disabilities. Many of the persons with disabilities were not aware of what was going on. So we think that the number is much more than 12.4%. But okay, even if we go with the 12.4%, still that number is not a mini number. So it is a number that we need to, to work around with. Again, it's a strategy for tackling poverty. Again, there's a very big link between disability and poverty. Persons with disabilities are likely to have more expenses than a person without a disability. Think of yourself as a mother with a child with a disability. How much time will you spend looking after that child? How much time will you take off work to take care of the child with a disability, or a mother with a disability, or a dad with a disability, or one of your siblings with a disability? You realize that you spend much more, yet your income may not increase. So that alone might affect your poverty. So disability is both a cause and a consequence of poverty, because we've seen many people getting disabled because they can't afford certain things. If you're working in community, you will get situations where people are telling you, I would have been better if I had this kind of medication. I would have been okay if I was, if I had not taken a border. But because I can't afford a bus fare, so that's why I chose a border, and I broke my legs. If I had this, so poverty is both a cause and consequence. Rather, disability is both a cause and consequence of poverty. Again, I've already mentioned that persons with disabilities have multiple barriers in securing some livelihoods. So again, the other is that when we are talking about inequality in general, but gender inequality is an issue. Persons with disabilities are left out or are discriminated, but women and girls with disabilities are more discriminated compared to their male counterparts. So if we are working in the area of gender and want to promote gender equality, then we have to specifically think about persons with disabilities. Then again, we know even women and youth without disabilities rarely participate in decision and leadership. But when it comes to women and girls with disabilities, then the situation is even worse. Social protection programs, again, women and girls with disabilities have low participation. They don't participate, they don't do this. When we shall be discussing the gender, rather the abuses, GBV, I will give you some scenarios that will show that actually women and girls with disabilities are 10 times more likely to be abused than women and girls without a disability. And there are reasons for that. So if a person is working or is providing a service in GBV and is not reaching out to women and girls with disabilities, then your services are good, but it's not good enough because it is leaving out a tenfold kind of people that you'll be living getting. So, I don't know if there are any questions. I'm not following in the.
And yes, if anyone would like to ask a question at this point, it might be a good place to pause. And also, specifically now that we're already discussing the gender dimensions of disability, and which I think is really, really important to our work as FIDA. And we know that disability as most, and as most of these intersectional aspects, really affect women in a very particular way. And so, if we have any comments, any questions, and any requests for clarification, this is an opportunity. Thomas, it seems we do not have any comments at this point. So let's move on.
So the next session, the next reflection is on is going to focus on, yes, we've understood the definition of disability. We have come across persons with disability, and then we are committed to reaching out to persons with disability. But then the question would be, how do we go about it? How do we go about inclusion of persons with disabilities in service provision? The first one is that please make an assumption that persons with disabilities will be the stakeholders. If you are in any business, or they'll be your clients, or they'll be your staff. So in other words, here we are talking about a 12.4% market share. If, for instance, we went to, and then we said for some of the cases that abuse, then you multiply the 12.4% 10 times. Then that means the number of workload that you have is going to be 10 times the kind of work you have now. So please make that assumption. Then you'll get the energy and conviction of, including persons with disabilities. Secondly, commit yourself to human rights approach to programming. Again, once you have that commitment, then you'll find it very easy for you to go about inclusion of persons with disabilities. If you're still in, charity, I'm helping these people, these people need help, then you're likely to be you're likely to struggle getting the impetus and energy to include persons with disabilities in your work. But if you're committed to human rights, then you have a very good reason for including persons with disabilities. And then as an organization, as a firm, as a person, can you develop consistent messages around disability? Can you make that commitment around including persons with disability? Then, like as I've said, we can talk about it as a rights issue, but also develop the capacity of your frontline people. You, even yourself as a service provider, can you understand disability so that, and ask yourself, if I'm to include persons with disabilities in my work, what do I need to do? What do I need to know? What do I need to do? What kind of adjustments do I need to make? So that you don't start from the other end, you start from yourself. And by the way, as you're doing this, we are not, of course, to scare any one of you, but I can assure you any one of us on this call are likely to become disabled at any one moment in life. You could be disabled because you have a road accident. You can sleep in your bathroom. You can take a wrong medication. You can, grow old. So in other words, when you're thinking about all this and increasing your knowledge around disability, please don't think of the other, but think about internally, what do I need to do? It was amazing to see Lynette, Deborah, Sheila on this call as lawyers to start talking about disability. I mean, for them, they studied the precedents, they started the language that you use. But now to start that, to recognize that we need also to understand disability and put it into our work starts with you at a personal, but as an organization. Then you raise awareness. In other words, you need to communicate to people. You need to tell people that, yes, you're there, you are you're providing this service, and you're confident. You can welcome. You can deal with anyone. Like for instance, if I were a job seeker and on one of your websites, I see that you're saying that I'm a disability confident employer, then definitely as a person with disability, I'll be encouraged to come in. If, for instance, you're organizing a legal aid clinic, and in your message you say, if sign language will be provided, then I know I'm welcome. If you say caption will be available, then I will join the call. If you say, or if I'm coming to an interview, or if you're calling me to attend a meeting and you ask me, what kind of support do you need? So already I know that you want to prepare for me, that you've understood, yes, I might have special needs, and therefore you want to prepare to prepare ahead of time. So if you can demonstrate that commitment through your board, through your documentation, through the kind of communication you're sending out, like many of you, I'm sure, who have been in the gender rights activism, you remember that there was a very big discussion on how to encourage women to apply for jobs. One of them was, if on the job advert, they would put that women are encouraged to apply. So in this case, if you have a job advert and you also include persons with disabilities are also encouraged to apply, that would also communicate something positive around inclusion. Again, a request for reasonable accommodation, and I'm sure many of the colleagues have asked what is reasonable accommodation, because again, when we are writing proposals, when we are writing concepts for activities, when we are writing reports, accountabilities, we normally, there is that line for reasonable accommodation. Reasonable accommodation in this case means that you are aware that there is a person with a disability who will need extra transport. For instance, if you had budgeted for 5,000 transport refund, because you know a taxi or a border charges 5,000. I can tell you when they are taking a person with a disability, they will charge more. Or that person with a disability will come with a helper. So you need to do that. Or in that meeting, you need a sign language interpreter, and there's a cost to that. So all those costs that come around, that is reasonable accommodation. And reasonable accommodation is not a new concept. It's not only limited to disability work, but it was also included in gender rights activism. For instance, this discussion of saying that women who are given 60 days maternity leave and men are given 5 days paternity leave. So again, that is reasonable accommodation. That women, especially if you recruited a young person and eventually during the course of employment, she gets married and now she starts asking you that I need to leave at 5 o'clock, then you need to understand it from that point of view, that you're trying to provide reasonable accommodation to that person. Or if a person says, I'm not going to work over the weekend, I have to take my family out or something like that, that is reasonable accommodation. So even when you're planning to include persons with disabilities in your work, you need to think about reasonable accommodation. Again, when you're trying to think about how to include persons with disabilities, you don't limit it to yourself, but you also you include it in your partners, but also include them as you think about persons with disabilities as part of that, yeah, in the work, either as partners or as staff or participants or clients. The other one is making a commitment. I've already said this. If we looked at your strategy, if we looked at your vision and mission statements, if we looked at your structure, if we looked at, you know, the organization, or if you are a team leader, the kind of setup, the kind of messaging you're putting, then that would indicate that you're committed to disability inclusion. So there are a number of principles that we can think about when doing disability inclusion. One of them is awareness, to understand disability. I've already mentioned this, and its implications. For instance, we need to boards, our stakeholders, our partners to be aware about disability and our commitment towards disability and how we care to make our work inclusive. The second one is participation of persons with disabilities. Sometimes it's very difficult to understand these things, but when you speak to them, when you involve them, like for instance, in this country, in this world, you would go to offices before the gender aspect came into being. You would go to office offices would be dull, the fashions would be, not good. But once we started staying both male and female in same workplaces, you find that some colors in offices are attractive, they set up, but if you go to an office which is only male dominated, you'll get that office is not, or that workplace, or even the programs are not, exciting. So it's the case with persons with disabilities. You may not know what to do, but if you have a staff who is a person with a disability, or if you are working with a person, or if you're working with an organization of persons with disability, you'll get a lot of insights on what needs to be done for you to include in your program. The other one is accessibility. I've already talked about it. Again, for you to get committed to accessible environments, both removing the physical barriers, removing the communication, working around policy, and the attitudes of the people that are within the culture of the organization and the rest. Sometimes many of the organizations that we are interacting with, they've come to appreciate some of these barriers, and instead they are avoiding them. One of them is saying, so that means if it means having a person, a wheelchair user, to be one of our staff, it means adjusting our toilet and removing all this, then we shall not recruit a person with that who is a wheelchair user. Or if it is asking for sign language interpretation, then we shall not invite them. So again, that is not a sign that you are committed to disability inclusion. The other one is a twin track approach. Again, a twin track meaning that we might want disability mainstreaming, which is the core of inclusion, but sometimes we might have special programs or special consideration for that. Yeah, mainstreaming is good, but sometimes we special programs or special interventions might do that. For instance, you might say, yes, we have put a ramp that goes to our chamber, so meaning that persons with disabilities are welcome. We have put all these other necessary accessibility features and the rest. But again, you might also want to say, for this year, my pro bono is going to be specifically for persons with disabilities. Again, those are the kind of special programs that could be. Or maybe you have organized activities and you say, okay, this activity is specifically targeting persons with disabilities, and these are my target areas. So again, a twin track approach. Again, evidence, that this one I don't have to labor so much. Again, sure we know the rationale of having evidence-based. Human rights, I've already talked about that. And again, Patricia is going to expand more on this. Gender equality, trying to address the barriers that come along with the differences between men and women. So again, we've already talked about that. The other principle is around multi-sectoral collaboration. The understanding here is that your services, you may not be the one providing all the services. So you need to think about working with others. For instance, you might be providing legal services, and yet you need counseling services as well, or you need and I'll give an example of organizations that are providing shelter homes. So if you're providing a shelter home, you might have legal representation, you might need social worker, you might need a health person, or people working in case you're working around aggravated abuse, things to do with people working on HIV/AIDS. So all this collaboration is very key for you to make your work inclusive. Again, I've talked about reasonable accommodation being part and parcel of your program, not as a, as you know, many people think that it is an extra cost. No, but you can plan it. We've already said that among your expected participants, think about a 10% of them being persons with disabilities. And you can, from a start, think about that category, even in your budget, even in your planning, even in your, you know, when you're planning the activity. So again, reasonable accommodation is one of them. The other is affirmative action. Still, persons with disabilities still need affirmative action to equalize opportunities. Again, the affirmative action could be, like as I said, if you could take a decision as a person or as an organization that we are going to set up a legal clinic for persons with disabilities, focusing on the issues of persons with disabilities, or maybe pro bono this year, or part of the pro bono is ring-fenced for persons with disabilities or something like that. So affirmative action is still very important principle for you to do disability inclusion. Now, just as I wind up this first segment, we need to remember that most people have come across inclusion as just physical access. We have ramps, we have a lift, we have put this, we have put that. No, that's not inclusion. Inclusion is much more than accessible ways. Physical access is important, but also the environmental barriers need to change. Environmental barriers, including the culture of the organizations, including the practices, including the policy, you know. So all these need to be thought about when we, again, especially when you're thinking about the wide range of impairments. So putting a ramp is only for people with physical impairments. If you think of the other list of the impairments I mentioned that are in Schedule 3, then you need to know that physical access is not the only way of demonstrating inclusion. Again, for emphasis, we need to think about sensory and learning as well. Where I'm emphasizing this, many people we have interacted with and who have attempted to do inclusion, they are not thinking about the sensory and learning impairments when doing inclusive programming. Again, when we do the environmental access, it will not only lead to inclusion, but it will also promote participation and decision-making within of persons with disabilities. And one thing which we came to realize is that when you make work systems, or when you make your service disability inclusive, even persons without a disability find it even easier to access and even more friendlier to work with. Yeah, so thank you so much. Let me pause here for a minute and see if there are any questions, so that we can now look at a case study, some of the case studies. Any questions? Any? I don't see any person putting up a hand. Lynette, have you been following what is in the chat? Maybe you raise.
Let me read a question from Sheila. So I can add that Sheila is the coordinator of one of the disability rights projects here at FIDA. And she says, she asks, what strategies can lawyers use to challenge ableism and promote disability inclusion in the legal profession? So it's really, how do you change mindsets in your workplace? And how can lawyers measure the success of their disability inclusion efforts, and what outcomes should they aim to achieve?
Ableism is a new term which shows that persons with impairments are a weaker person compared to persons without. So again, when you see a person on a wheelchair, you think that that person is less able compared to a person who is walking straight. Again, that is a very, still a big problem. But when we understand disability from a functional point of perspective, again, you realize that aspect will not be a big problem, because we are looking at a person, we are looking at the functional abilities of a person. Yeah, if a person, and I'll give an example that right now we have a number of lawyers, since you're in the legal profession, who have a disability but are also very successful in the legal profession. So again, leaving out that. So again, ableism is something which we need to continue, sensitizing, but also trying to adjust the culture. Again, when we look at the case study next, we are going to see how we can do away with the ableism with that. And how can lawyers measure the success of their disability inclusion efforts? Just think of any service that you're providing. And let me give an example that many of you are providing legal aid, or some of you have these call centers. Yeah, if you checked in the call center and checked how many drop calls, and you've not done a thorough analysis of the reason for the drop calls, then you know there is a problem. But then as a lawyer, you need to check how much of the law on disability, like Patricia is going to take us through, regarding that. How many of those have you worked on in the last 5 or 10 years? And therefore, how come that from practice, from what we know, that many of the cases are involving persons with disabilities, but for you as a lawyer in your career, you've not come across any? So does it mean that you're not seeing them, or they're not coming to you? Then you need to do that self-reflection and ask, why is it that I'm not working on this, yet they are the most of the cases that they are? Yeah. So Lynette, you've raised your hand.
Yes, Thomas, that was really just to alert you to the question in the chat, which was Sheila's, which I think you've now addressed. And so I think we can move on to the next thing. Unless there are any other questions or any other responses to Thomas's presentation at this point. And as you know, we have many legal officers, legal assistants on the school, who are all really charged with this responsibility of making legal aid inclusive, making it accessible. And so we are all on this journey together. And I know that there are really practical difficulties that that come along across the, along the way. And I think, we are all increasing our practice little by little in knowing how to do this well. So if you have a particular question that that relates to a case that you have handled or that you're handling at the moment, and this is a really good space to get advice, to get guidance, and on how to provide that better. So please don't let this training go by and we've not made use of Thomas's expertise. But otherwise, unless you have a question right now, Thomas, I think we can move into the next. We can move into the next part of your session.
Yeah, I think the next session is going to be around some of the issues that we come across quite regularly. Injustice is in a number of areas, but I thought we are going to look at two today. One is there's a lot of injustice around access to rights, like right to employment. Yeah, I'm sure many of you have heard those stories that I was denied the opportunity, I was mistreated at workplace, I was dismissed because of this. Again, I want you to think about that in relation to persons with disabilities, and you try to come up with scenarios where a right has been denied, and it is your responsibility to support that. But the other one that I wanted us to reflect on, again, as people working in organization, is around people living with a disability at workplaces. And I've not discussed I've not discussed the issues with the other areas, because like GBV, because we have a session in the afternoon. But I wanted us to reflect on one of the biggest problems that is affecting our work and within the organizations that we are working in, but also within the communities that we are working in, and that is disclosure. So, just by show of hands, how many of you disclosed your disability when you are joining your job? How many? Just by show of hands, how many disclosed that Temwa, your Agnes? Yes. So, one of the challenges is living with a disability at a workplace, to disclose or not disclose. And I'm bringing this from a workplace perspective, but I want you also to think about it in terms of your groups that you're working with. I want you to think of them as the sessions that you conduct, the kind of people you interact with, the kind of participants you like it to have. So when you are in a group meeting, or if you're in a community meeting, or if you're in a setting in an office, in workplace, and the rest, one of the things that one of the things people don't do is disclosing that disability. So you may want to place a workplace, in this case, with a session or a community meeting or a workshop or in a class like we have now, or like, anything, as long as the question is, do people disclose or they don't disclose? And I'll give you a case study of 2017, where in one of the companies, big companies in the US, they found that 30% of the employees had some form of disability. But only 3.2% of those employees had disclosed the disability. So that is almost 10%, less than 10% of the people had not disclosed the disability. And many of those that had disclosed had used informal means, such as through peers who informed management. So in other words, you'd imagine this company didn't have a policy for allowing or enabling people to disclose. Or so meaning for you are there as a service provider in a legal aid clinic, you've not given an opportunity to people to disclose their disability. So you'll see one of the participants telling you, so-and-so wants you to repeat, so-and-so is not following, but actually the person has not done that. Or for you as a person, you've not opted to support that person to do that. Or even the 3.2% were noticed by peers and raised a concern during the performance. And employees with disabilities who are disclosed were as twice as content on the job as those who are not disclosed. So again, to emphasize that here in Uganda, we have 12.4% with a disability. So when you look at this, you have 30% of the people with a disability, only 3.2% are disclosing. And even those who are disclosing, they are disclosing through peers or using informal means. And then, but those who are disclosed were twice as content. In other words, when they disclosed, they were more focused on the job, they were more focused in the training, they were more focused in class, they were more focused on the task. So in other words, hiding a disability has some consequences. So again, to reflect back to what we said in the first session, was that some impairments are visible. You might see my clutch, you might see my wheelchair, you might see some limbs missing, you might see, but some impairments may not be visible. I might have a sight impairment, but using glasses, you may not know. I may not have a limb, but have an artificial one, so you may not know. I might be having a hearing impairment. You can't see. You might see me smiling, you might see me, as if I'm following, but when actually I'm not hearing what you're saying. So we need to remember that some impairments are visible and others are not. And the invisible ones are many more than the visible ones. And then the other one is that any person can be as productive at a workplace or in a training or in any activity with or without an impairment. So in other words, a person having an impairment doesn't stop that person from being productive or efficient at a workplace or in an activity or in a meeting or in anything. So an impairment is not a problem. So the workplace or that activity, when you organize it, if you organize a clinic, when you organize training, that is very important in enhancing disclosure is very important in enhancing productivity, but also that person being efficient. Employees can come to the company with a disability, but others can get a disability during employment. Again, I'm using employment as a case study, but we can think of a scenario that you could be doing a training and the person acquires a disability there and then. You're moving from Kampala to Jinja, your colleague gets a disability there and then. Or you're moving, or even yourself, you're at home, you can get a disability during the employment. So the issue is not you getting that disability, but the issue is how the organization deals with that situation. So disclosure is voluntary, so that is so it's not illegal not to disclose. So that is point number one. So meaning yes, it's not illegal and it is voluntary. So for you as a service provider, as a person who is doing this activity, if you know it's voluntary and it's not illegal, how are you going to deal with that? Are you going to enforce? Are you going to force people to disclose? Are you going to? So what kind of things are you doing for you to promote that voluntary kind of disclosure? So again, when we are planning these activities, we should be aware that people are not disclosing. So going back to Sheila's question, how do you measure your effectiveness as a lawyer? It might be difficult for you to measure if people are not disclosing. You might work with a client or you might work on some activity and you don't record it as falling in this area of disability because people are not disclosing. Some information is collected. Yes, we know some information is collected on personal data forms or medical reports. In employment, when you're reporting, people ask you to fill a certain form, blah, blah. But again, on those forms, not everything is disclosed. But also on that form, like many people, when we go for workshops or when you're going for these other meetings, you might have your attendance sheet and then you put a column for people to say whether they are disabled or not. Again, a person might choose to put or we may not put. And from experience is that when you're beginning and when people have not, when you've not created rapport with them, many people will say they don't have a disability. But when you progress with the time, then they'll eventually disclose. I'm sure many of you have come across such a scenario. You stay with a person, and after 1 year, after 2 years, that's when you start getting to know that person and what kind of things the person requires. But we should also remember that disclosure is protected by law and policy. Again, I'm sure you know most of these laws. Again, disclosure can be at any stage, whether at entry or during employment. Making a decision to disclose your disability can be challenging. And many people are struggling to find the best time to disclose. Again, we need to be aware of this. We need to be patient with the people we are working with, especially when it comes to disclosure. Again, so the question will be, what would be the best time? Do you do this disclosure after encountering barriers at work? Many people have suffered, and this especially when it comes to appraisals. You find that the performance of a person has been appraised poorly. The performance is poor, not the expected levels. And when you're discussing with a person, that's when a person says, I would have performed much better if I had had this, or if I had been treated this way. So meaning that sometimes people disclose at that critical moment when they are encountering a barrier. Yeah, and many of us who have house helpers at home, a house help may not disclose a disability. You only realize that disability when the person has broken the glasses, or when the person has mistreated your child, or when the person has, demonstrated a weird behavior. That's when you realize that, oh, this person had this kind of disability. But from the start, so in other words, many people disclose after encountering barriers, especially when people are being sacked. That's when they say, I'm being measured or evaluated badly. Like for instance, if you're organizing your activity, you might realize that the learning outcomes may not be achieved at the end of the session. And when you check the reasons why people have not grasped, or why the learning outcome has not been achieved, that's when one of the reasons comes out that, oh, we were not hearing you properly. Oh, we were not able to understand that the language you're using. Oh, so in other words, that disclosure usually comes at the end. Again, how to disclose sometimes becomes challenging. Again, as a person who is trying to do disability inclusion, you need to provide all these platforms. You need to be aware that it is difficult to disclose a disability. So you provide a number of avenues for people to provide that disclosure. Either you have peer support groups, or you keep changing the supervisors, or you keep a number of ways that you would want to make this person comfortable, so that the person can be able to feel comfortable and disclose. There are reasons why people don't disclose. Of course, we fear to lose opportunities. If I tell my boss that I'm a person with disability, I immediately lose a job, or I immediately lose a relationship, or I immediately start, people start looking me differently. Some have reported that, of course, in relation to that, there are people who have told us that when they disclosed during interviews that they have a disability, that was the end of the process. Some people have told us, even if they don't disclose, but once the employers or the people we are working with realize that there's a disability, then that's the process stops there. I'm sure you've heard of these scenarios where you get shortlisted, you are invited for the interview, and immediately you walk in the interview room, they see you two people walking in, and then they start asking, we invited one person, how come that you are coming in with another? And forgetting that you come in with your sign language interpreter. Or they see you walking with a wheelchair, then immediately their perception on your competence is affected. So all these are some of the things that we need to be aware of when we are thinking of disability inclusion. So, of course, some of people have reported that they've lost employment on asking accommodations. For instance, you might say, for me, since I joined this organization last year, I got an accident, and therefore I need a new desk, or I need a new computer, I need a big screen, and that alone, the organization looks at you as a demanding person. So for people to fear that loss of trust they keep with their. Of course, there is stigma. If I tell people that I'm epileptic, they might start fearing me. They might start looking at me with the certain gestures, or they might start, corridor talks about my disability. So I fear that stigma. So I will not disclose. Discrimination, again, talking about what Sheila was talking about, ableism, where people think that persons with disabilities are inferior to able people. Again, that sometimes causes fear for discrimination once a person discloses. So again, because of that discrimination at work, that culture of promoting ableism will enable our participants or the people we intend to provide the service to fear to disclose their disability. And of course, if they don't disclose, then you can't find an appropriate way of supporting them or of providing the service that you want to provide. Infantilizing, most people fear to be treated like infants all the time. Most people, once they tell people that I'm a person with a disability, then everybody want to keep you like an infant. They want to support you. Can I bring you water? Can I bring you this? Can I take this for you? And yet the person is okay with doing whatever they are doing by themselves. So infantilizing is a very big issue when it comes to disclosure. Like for instance, if you had a class of students and then you, in your training, a person tells you that he's a low learner, then every time you want to ask that person whether he has understood or not, every time you are, so it is sort of traumatizing to that person to be treated like an infant or to be treated like a person who is. So if you a person who is fearing that, then you are likely not to be to disclose your disability. However, disclosure is beneficial, so why you need to think about encouraging your participants or your clients or your stakeholders to disclose, or your staff, is that first of all, it protects your human right as a person with a disability. Yeah, because you have rights as a person with disability. So if you don't disclose, if you don't encourage them, then they'll not be able to do this. So when you're organizing the clinic, when you're organizing a class, when you're organizing, and you need to put it to them that once they disclose, then they'll be able to benefit from the protection that the organization provides to persons with disabilities. Then reasonable accommodation. Again, as you will see in the Persons with Disabilities Act, reasonable accommodation is mandatory. It's no longer provisional. It has to be provided as long as I need it. So if you don't disclose, then you'll not be able to have that reasonable accommodation. Again, it enables you to explain yourself, because if you're a person with hearing impairment and all the time I'm putting earpins, a person might think that I'm being proud or I'm being disrespectful. But this person needs to be told that those are my hearing aids, they are not earpieces. Because most people have hearing aids, but when you ask an ordinary person, they look at them as earpieces. Yeah? Or if they see me all the time putting on dark glasses, a person might not understand it until when I disclose that it helps me. Or if I need to put on long-sleeved things or have frequent visits to the washrooms, or even frequent visits to the doctor, or eating frequently, because eating alone, a person might think that there is a problem, or maybe I'm stressed or I'm what. No, I may not be stressed, but it might be a requirement because of the kind of disability. So until when we encourage our participants, our stakeholders, our staff, our people that we provide service to, imagine a situation where you're seated with a client and is explaining, you're documenting, but every time the person is going to the washroom, for you as a lawyer, you might think that this person is not serious, or you might think that the person is wasting your time. Or imagine if you are the judge and you need to use the bathroom all the time. At every 30 minutes, you're adjourning a court session. Or if but if you disclose, then people will understand why you're doing certain things. It doesn't only apply to the the recipients of your services, but it could also be to you as a service provider. Imagine a situation where you're doing a clinic and you have to take your medication. So every time they see you excusing yourself, and instead of taking your medication in a proper place, you have to rush to the toilets to go and take your medication separately. And I mean, it's not worth it. So disclosure is to of your stakeholders, but also of you, the service provider, is very, very important. Again, being a person with disability has some financial incentives that come with it. For instance, if the employer, again, you realize in that there's a provision for tax exemptions if you are employing a certain number of persons with disabilities, or if you're a person with disability, there are certain tax exemptions that you can benefit from. For instance, if you're buying a vehicle and you want a modified vehicle because of your type of disability, you can request and you get duty-free or tax exemption for that. Or if you're an organization and you're getting some equipment because of because you employ persons with disabilities, some of those equipment might have tax exemptions. So again, it has a financial benefit if you disclose. Again, it gives an opportunity to provide mentorship, to organize how to support your team or how to support your stakeholders or your partners if they disclose their. Again, there's job satisfaction for people who have disclosed, have reported that they have a more job satisfaction compared to those people who have not disclosed. Again, for people who hide their disability, find it discomforting and exhaustive, not only to themselves, but also to the fellow workmates. For instance, I'm sure you've had people that you don't understand that person. That person is difficult to travel with. And the reason why they are saying that person is difficult to travel with is because they have to stop at every petrol station to use a bathroom. Or why that person is difficult to travel with, because that person eats badly, munches food badly in a vehicle when traveling, or when you're seated with a person when traveling in a bus or whatever. So it is, and again, for you as a person who is hiding, you use a lot of effort. I've known a colleague who was coming in at 6 a.m. every day and leaving at 7 p.m. So people would find him seated, and they would leave him seated on his desk simply because he didn't want to show people that he has a problem in the way he was working. So, but you would imagine the effort, the discomfort the person was putting in that. So it also happens in your sessions outside, in your class, in whatever. If you find a person who is, hiding a disability, will disorganize you as a trainer, as a service provider, as any person, because it will be difficult for you to try to figure out what the problem is. Is the problem you, the service provider, or is the problem the people who are receiving your service or getting your training? So it is very exhaustive and destructive. So encourage disclosure. Of course, it improves compliance if you disclose, and you as an organization, as a service provider, you can provide all the what is required for all your stakeholders. Then your compliance levels increase. What can be done to encourage disclosure? Again, statement of intent, communicating the commitment to inclusion. For instance, when you check your policy, does your policy allow me to disclose my disability? Is your value system within the work environment, within your home, within your organization, within your team, is that value system promoting disability? Does it allow me to feel comfortable with my disability? Are the promotional materials and events communicating that I'm welcome as a person with disability? Or the promotion of disability materials leave me with some questions whether I'll be accommodated? For instance, if I came and saw your poster, like as I said, does it have that confidence in me that there will be captioning for me to join this call? If it's not clear, yes, I might join and see for 5 minutes and then I switch off. So again, the people that are providing the service, do they promote that culture? Have they communicated about how they are going to treat me? Do they keep my data properly, or are they going to use my data for further stigmatizing me as a person? So the other way of doing it, of course, as I conclude, when we encourage people to understand disability inclusion, and when we communicate that and undertake to fully commit to inclusion, then that disclosure does not only enable the employees or the stakeholders or our students, but also it enables us as service providers to deliver a service in a good and justifiable manner. That we find that for me as a service provider, I'm satisfied, but also the people that I'm providing a service to are also satisfied. So I want to stop here, and I guess I've confused you enough. And I think you found some of these reflections beneficial, but it will make more sense when you back it up with the legal provisions that Patricia is going to share with us after the break. Thank you so much.
It's been really interesting, and even for many of us who have been part of these kinds of trainings before, it's so important to constantly be learning and constantly be challenging your own practice, your own procedures, your own way of organizing events. And so this for me has been a really informative session. Do we have any questions at this point? I think it will be helpful if we can take a few questions that come up now or that have come up during the session. You're welcome to put up your hand or just place a question in the chat if you have any. Right, it seems we do not have any questions. And so that means we are ending our session a little bit early. We had up until 11 a.m. and it's just 10:50 now. And so let's take a 30-minute break. And this has been a good 2-hour session, so I think a 30-minute break would be appropriate. And then we start with session 2, that will be led by Dr. Patricia Atim at exactly 11:20. So enjoy your break. Thank you. Actually, you can switch off the microphone. Okay. And welcome back from the break, everyone. I hope you had a cup of tea and a bit of a breather, because it was quite an informative and full first session. And we are now very excited to move into our second session of the training, which will be led by Dr. Patricia Atim. And this session will focus on the legal framework that protects the rights of persons with disabilities in Uganda. And we'll also look at specific guidelines that are quite new and that have been adopted to guide practitioners in managing cases of persons with disabilities at the court level. And so, Dr. Patricia, we are very excited to hand over to you and to hear from you.
Got it right. Hello. Okay, good. Okay, good morning. Okay, good morning to all the participants here. We thank you for taking off your time, precious time to really engage and come and engage in this conversation where we are talking about the rights of persons with disabilities and how we in the legal fraternity can intensify or deepen our efforts towards protecting the rights of persons with disabilities who come to our law firms as our clients and otherwise. So the task at hand for me this morning is to take you through an understanding of the legal frameworks that protect the rights of persons with disabilities in Uganda. And looking at the feedback from the survey tool that you just responded to, at least a good number of you expressed limited knowledge in understanding the rights and the laws that protect the rights of persons with disabilities in Uganda. We were able to identify, some of you were able to identify a few. Others wanted to understand the intersectionality between gender and disability. And we shall look more into that in the third session of the day. Better understanding of disability law, disability rights. And thank you very much, Thomas, who spoke earlier, for giving us a very comprehensive understanding of what disability is, what impairments are, how disabilities actually arise from barriers in our society, barriers that inhibit persons with the various kinds of impairment from having their greatest potential in terms of functionality and being able to execute their different roles in their different capacities simply because of the barriers in place: attitudinal barrier, environmental barrier, procedural barriers, institutional barriers that were all listed by Timothy. So thank you very much, Timothy, for that. Now, members, I thought maybe we could start off this session by watching a video, a small video clip. It runs for about 3 minutes, and then we'll take you into breakout sessions. In those breakout sessions, being lawyers, and we are probably joined by persons who are also not really lawyers, but that's fine. We'll all work together in our breakout sessions. In the breakout sessions, we will try to discuss in those groups. There are 3 breakout rooms. We will discuss the first group, or first room, will discuss the issues emerging, the legal issues emerging from the video. The second group, or the problems that are expressed in the video by the women with disabilities. The second group will look at the legal framework that they think as lawyers they can rely on to present and enforce the rights of the women. And then the third group can talk to us about the strategies, legal strategies that they would adopt in trying to enforce those rights. So let's watch the video for about 3 minutes, and thereafter we can have break off for our group discussions for about 7 minutes or so. And then one group member can report back on their findings along those parameters. Then we can go into the deeper presentation. Thank you very much for your cooperation. I am I implore you to please allow me to, or us, let us work together positively right now so that we see what emerges from the session. Thank you very much. So let's watch the video now. Trevor, please.
One form of disability. The United Nations Convention on the Rights of Persons with Disability guarantees persons with disability the same level of right to access quality and affordable health care as persons without disability. However, according to women with disability, accessing maternal health remains a major challenge to them.
It is also on another national duty in the mental area.
Zawede, a disabled mother, recounts the unfair treatment she received from one of the health facilities at the time she was pregnant.
When I started my antenatal visits at Wakiso Health Center 4, I was asked to pay 450,000 upfront because I could not give birth normally. There is a time I had a stillbirth, and when I did a CT scan and took it to the health center, I was not helped. I had to proceed to Kawempe, where I finally got help.
Zawede appeals to the government to establish disability-friendly health facilities to enable people with disabilities access them.
We need government to put special hospital staff for the disabled. Also, the maternity beds in these health facilities are unfavorable to us.
Sarah Najuko, a visually impaired mother of two, wants the government to introduce punishment for men who sire children with disabled women and neglect them.
We need a law on men who engage disabled women in intimate relationships. This way, these men will engage disabled women in intimate relationships. This way, these men will probably not abandon their responsibilities.
Women with disability are also victims of sexual gender-based violence. However, many complain of the unfair treatment at police stations where they report their tormentors.
There is a police officer who asked me to sacrifice a part of my body so as to help me in case I had reported. I could not do it, and I also didn't have money. I had to give up the case.
This was during a stakeholders meeting aimed at improving the livelihood of women affected with disability. Irene Karono from Sense International recommends mandatory neonatal screening for any forms of disabilities.
Ideally, at birth, every child should be assessed and any impairment identified, and once that impairment is identified, to see if any can be corrected, maybe through stimulation support or surgery, and in case it cannot be corrected, to see how that child can be supported to grow so that the other aspects that do not have impairment can be hoped to their best.
Rachel Nachwala reporting for the news.
This year, the African
Okay, welcome back, members. So I hope you have enjoyed that small video clip to kind of give us a feel of what some women with disabilities go through even in the health centers, as expressed by those ladies. So just like we said earlier, can we please break into our groups now for just about 5 minutes, and we see how you answer the different questions there. Group one, I understand you've already been divided into groups. You have breakout rooms. Yeah. So people in breakout room one, you look at the issues emerging, the legal issues emerging from that scenario. Yeah.
Groups are named red, green, blue.
Okay. I understand the groups are named red, green, and blue. So group red, you look at the legal issues emerging from the scenario. Group green, you look at the legal framework that you use as lawyers to enforce the rights of the women with disabilities from that video. And then group three can report to us about the legal strategies that they would follow. So let's just take 5 minutes trying to have a conversation around that. Thank you very much. We'll resume at 11:37.
James, I haven't enjoyed the breakout room. It just gets
Hi,
Hi
Sheila.
members, again, we are
Please
supposed to
join the
discuss the
group
legal
you are
issues
assigned to.
emerging from the videos. Anyone, any
Okay, welcome back from the breakout rooms. I hope you had a good time trying to digest the video and also get to know each other, one another better as group mates and participants on this call. So let's hear from maybe Group Red. Group Red in just 2 minutes. I think each group will just have about 2 minutes to report back. So which legal issues did you find emerging? One person from Group Red. So, if your group didn't really get to do any work, you can also just say, pause us. We know some groups had challenges because they probably didn't watch the video in time. Okay. Yes, right.
Yes, this is Team Red.
Yes.
Apologies. Really, my entire team didn't watch the video, and we were requesting if we would be given a rewatch briefly so that we'll come up quickly with something. Everyone almost joined late for different reasons, so we weren't able to watch the video fully. Sorry.
Okay. Okay, maybe at a later time we will probably show the video again for our digest. But thank you for being there, and could hear you calling on your group members to say something. Yeah, so group green, what legal frameworks. But otherwise, okay, as we wait for group green, the video was about women with disabilities trying to access reproductive health care, maternal health care from the hospitals, and they were being denied because one, the hospital facilities were not accessible for women with physical disabilities. And then one of the women also complained about the attitudinal barrier that the health officers or the health personnel did not treat them right in the hospital when they sought maternal health care. Then they also talked about men who have intimate relationships with them, and then once they have children or get pregnant, the men abandon them. So they were calling on the government to also pass legislation that to ensure that holds men accountable, men who have intimate relationships with women with disabilities, so that they are accountable and they support with childcare and so on. And then one of the other ladies also expressed one of the challenge she faced when she went to the police station to report the matter, and the police simply asked her for money. Oh, my network. The police asked her for money instead, and she could not continue seeking justice because she did not have the 450,000 that the police had asked her to bring to police before her case could be heard. So those are some of the issues that emerged from the video. That was the story. And of course, the issues speak to one, the right to reproductive health care for women with disabilities if they cannot access maternal health care from the hospitals. There are issues around accessibility, and we had earlier during Timothy's presentation that the environment services must be accessible for persons with disabilities to reach them, access them, and enjoy them like all other persons or their non-disabled counterparts. And then parental rights and obligations is also another issue that emerged that I could see. And then denial of access to justice, because if you go to the police station and report your case, and the police, your prejudice or the stigma from the police officer, they think you should not be coming to report your case. And then two, you asked for a bribe. Those are issues of corruption that increase the cost of seeking justice in this country. And ultimately, she said she could not go back to the police station because she couldn't take the 450,000. So that means her right to access justice is also inhibited to that extent. And then the right to dignity, because they also expressed that they were being abused by some of the health personnel where they went for maternal health care and so on. So that also speaks to a violation of the right to dignity for women with disabilities. So those are some of the emerging issues I could see from that video, and we can work with that. So, the group green. Group green.
Good morning.
Yes, good morning.
In my group, I was with Claudia only, and we looked at different policies or different laws that can protect women when it comes to their health and reproductive health in general. The first law that we looked at is the International Convention on Rights of Persons with Disabilities, and this one specifically, when you look at Article 4, it takes away it brings about all the appropriate measures that we can use, or the government, like it brings in an aspect of the fact that our state, Uganda, has ratified to this convention. That means they are supposed to ensure that the rights of persons with disabilities are promoted and protected at all costs. So Article 4 itself looks at us adopting appropriate legislation, administrative and other measures to ensure that their rights recognized under the convention. Also, it also looks at looking at the different laws and also abolishing any laws that are against or customs that are against rights of persons with disabilities. And this looks also at the health aspect. Also, it emphasizes taking appropriate measures to eliminate discrimination when it comes to persons with disabilities in general, and this also includes health, the maternity health and others. Then also we looked at the African Charter on Human and People's Rights. This one mainly is at the regional level of Africa, and it looks at the human rights. Of course, looking at the human rights means persons with disabilities are humans like they're person with us, so their rights are protected even at the regional level. So when you look at our constitution, 1995 as amended, it brings into most of whatever the international convention on the rights of persons with disabilities states therein has been included in our constitution for the Republic of Uganda. So this one brings out aspects of things like communication, especially for women with disabilities that have a hearing disability, disability. Yes, sign language being one of them. It's one of the things that can bring about an aspect of accessibility to information, say for the pregnant women that are going to, that want to access the health services, but also it also looks at the aspect of accessibility to all services, whether social, whether economic, whether political. So here we look at the social aspect of it, which includes also things like health services. Then also it looks at, the Constitution also looks at bringing into place laws and policies that are in favor of persons with disabilities. Laws and policies here, we are looking at the national policy on disability in Uganda. It's a policy that really tackles education, it tackles health, and it tackles issues like HIV/AIDS. It tackles things like access to health and access to drugs, and this being closer to these persons for their accessibility at the end of the day, bringing a service closer to them. But then it doesn't talk about the aspect, there's a gap of the flexible maternity beds in there, so that has to be tackled. The other thing that we looked at was the Person with Disabilities Act. It's also, Parliament was given that mandate, and indeed they came up with this law that generally provides for the rights of persons with disabilities therein, and right to health is one of the rights that's being emphasized. Though, like we've said, there's a gap in there when it comes to what the other lady talked about, accessibility, and how rude and discriminatory and how they're being there's an aspect of stigmatization when it comes to women when they're accessing when they're accessing health, and also the derogatory terms that they use, like how did you come to get pregnant if you're disabled? There's so many rude remarks that are made through these women. So there are many other policies there in. I don't know, Claudia, do you have anything to say? Thank you so much.
Thank you. Okay, I can see claps. Yes, we clap for green. Very good submissions. There's some hand. Yes.
A hand from Nora.
A hand from Nora. Nora?
Yes, I was also part of that group, and we're cut short by time, but some of the contributions we also had regarded, because the question was asking for the legal framework, so as to ensure that the legal framework would use as lawyers to enforce the rights of persons with disabilities. And my friend has elaborated on some of the rights, but we looked at also the Equal Opportunities Act, the Employment Act, which I already talked about. Then there was this convention that we also looked at, the 1993 Vienna Declaration and Program Action, and with it basically provides for a special attention to be given to attention in order to ensure non-discrimination and enjoyment of all rights and fundamental freedoms by disabled persons, including, and with it, it also calls for inclusivity, like to ensure their active participation in all aspects of society. So those are some of the laws we would rely on. Then we also talked about public interest litigation as activists or as lawyers would also delve much into it, public interest litigation.
Okay. Thank you very much, Green. And then finally, can we hear from Blue? And Green spoke a bit about Blue's task. Yes, Blue?
Thank you so much. So as the Blue group, we had to discuss the legal strategies that we can adopt in addressing broader issues faced by persons with disabilities. And during the discussion, I must confess that we ended up discussing group green issues, but I believe my group members will support me. But some of the legal strategies that we can take on One, providing legal aid to persons with disabilities. Legal aid, and this will encompass representation of persons with disabilities in courts of law and even during mid-ADR sessions that are being held. And this is because in regards to Thomas's presentation in the morning, he stated that disability is both a cause and a consequence of poverty. So you note that when someone has a disability, they have a number of challenges, and one of them is going to be poverty, which will not enable them outsource the services of a lawyer that requires payment. But if we are able to offer legal aid to persons with disabilities, then we are able to not only make them feel confident in the legal justice system, but also be able to voice their concerns when it comes to public spheres. The other one would be policy review. This would require us to analyze and advocate for policy reforms that ensure inclusivity and accessibility. When we look at the Penal Code Act, there's a section that provides for aggravated defilement and some of the ingredients for aggravated defilement, one of them being in case the survivor was an imbecile. So the term imbecile was taken to be derogatory in nature, and there has been work done around trying to do away with this terminology in our laws. Then another would be advocating for policy reforms and legislative changes that promote inclusivity and accessibility. That is how we come up with the Persons with Disability Act of 2020, that encompasses the rights of persons with disabilities to ensure that they are included, and in case they're in workspaces, they are able to access one or two things around them. Then the other would be collaboration with partners that deal with persons with disabilities, or even if they do not deal with persons with disabilities, still working closely with partners to ensure that persons with disabilities receive a much more holistic intervention besides the intervention that they seek to, for example, get from FIDA, which would be legal aid. So you find that besides the legal aid that they want to get, there are other underlying issues. For example, in Karamoja, you find that besides the legal aid, someone would want to have food, someone wants to have shelter. There is a child that has been sexually abused and needs temporary shelter. So that would call for a much more collective effort to ensure that the person with a disability actually receives a much more holistic intervention. The other one would be capacity building. You have to build a capacity of all employees, of stakeholders within the places where we are working, to ensure that they are much more alive and sensitive to the daily growing needs of persons with disabilities. When we build their capacity, then we are able to come on a round table and discuss some of the ways in which we can resolve some of these issues. For example, the government has the special grants that it gives to persons with disabilities all over the country. But then you find that some of these persons with disabilities do not even have the knowledge, or even if they have the knowledge about the grant, when they get the money, what they want to solve is just the immediate needs that they have and not the long-term needs that will end up benefiting them. So if we can work together with the stakeholders we have on ground to ensure that we educate the persons with disabilities about the special grant and how it needs to be utilized, then it is one of the ways we can try to address economic violence that persons with disabilities are actually facing wherever they are staying. Then lastly, what I would love to discuss is creating awareness amongst persons with disabilities. So you find that in far-to-reach areas like upcountry, Karamoja, West Nile, persons with disabilities do not actually know their rights fully. And so they stomach these violations that they go through because they think that is the daily routine and it's acceptable in society. But if you can raise awareness and educate the public and persons with disabilities about their rights and how violation of their rights can be tackled when they seek this legal aid, then it's it would be a strategy that we can adopt to address the broader issues that persons with disabilities are actually facing. So those are some of the strategies I have come up with. My group members, we discussed something different, but if you have something that you would love to share with us, kindly please do share.
That one has a future in strategic investigation.
Boy, that's very interesting. Thank you very much, Group Blue. Yes, for also that very informative and very useful strategies. And these are strategies that we all use in our different areas of work in trying to enforce the rights of the different groups of people that we serve from our different organizations. And indeed, there are also very good strategies when enforcing and realizing, promoting, protecting the rights of persons with disabilities. So thank you very much, all three groups, for your very useful and effective cooperation in this. Now, let us have an overview of what I had prepared and many of the laws you have actually mentioned them. So you see, we are rich in knowledge. And my instructions from UNED was that we focus on the area of access to justice. So let us, I have to work. Okay, so legal frameworks on the right to access justice for persons with disabilities in Uganda. Move to the next screen. Don't have to share the screen. You have to. Okay. So I think I started off by asking ourselves, why should we as lawyers be concerned about providing or protecting, legal services and protecting or promoting the rights of persons with disabilities? We are enjoined by the provisions in the law. We have, if we are to look at the UN CRPD in its preamble, it calls on all individuals having duty towards other individuals and in the community, and the responsibility to strive harder to promote and observe the rights which are protected in the International Bill of Rights. And the Bill of Rights, as we'll see, about 3 international documents that are usually referred to as the Bill of Rights. So we have the duty, even in our own constitution in Uganda, as citizens, we have the duty to protect and promote the rights and freedoms enshrined in the Constitution, and to protect children and other vulnerable groups from abuse. Persons with disabilities are often categorized as vulnerable groups because of the different challenges that they go through. So what is access to justice? Most of us are lawyers here, so just briefly speaking, we are familiar with these terms. Access to justice is a broad concept encompassing persons, people's effective access to a system, that's the justice system. The procedure should be accessible. The information in the justice system should be accessible, and the location of the justice system should also be accessible, including all the judicial or quasi-judicial settings. And sometimes, and this definition I picked from the CEDAW General Comment number 33, which is on the access to justice for women. And the CEDAW defines access to justice looking at both the formal justice sector, that is our courts, our formal justice sector can trace it back from the LC courts to the highest court, the Supreme Court. And then we can also look at the informal justice sector, which is the community, the clan leaders, etc. All those sectors that administer justice to the people or provide justice to the people must be accessible. So the elements that constitute access to justice include accessibility, of the justice forums or platforms of the yellow sector, the police. They should not be so far away that the distance alone deters people from accessing. Now you talk of all people, then you're talking about people with disabilities who have already a double disadvantage because, or even triple, because there's a disability they have to deal with. And also you look at things like costs, economic burdens due to poverty and so on, that they also have to deal with. So accessibility is one, availability of the information that leads to access to justice, affordability and availability of the legal services. I'm happy that Group Blue identified provision of legal services or legal aid services to persons with disabilities because they're often characterized with poverty and inaccess to the high costs of litigation, as we all know in this country. So legal aid becomes very important when dealing with a vulnerable group like persons with disabilities, providing services. Then once the enforcement forum has been accessed, the legal aid service provision has been assessed, access to justice also means the remedy must be timely and effective. We should be able to realize the remedy that a litigant seeks. So those are the different components or elements of access to justice. However, from the Hills report, that report that I cite there, it's the Hills, let's go back to it a bit, that I would implore all of you to read, Justice Needs and Satisfaction in Uganda 2020. It confirms that there is limited access to the formal justice sector by our people, limited access to lawyers and the use of lawyers. Many of our people, especially in the vulnerable groups, are seeking justice from the informal justice players. And the furthest most of them go is really in the LC court structures, but not us. So this means that as lawyers, people in the legal fraternity or players in the judicial sector, we need to do a lot more work in increasing accessibility for our services. And now when you talk about even persons with disabilities, then we go back to the conversation earlier in the day, how accessible are our services, how convincing or how much confidence do our clients or the public have, the persons with disabilities have in the fact that our offices are open and committed to also serving persons with disabilities. So that will increase the level of access to justice for persons with disabilities, among others. There is also a last minute report, which is very useful, access to justice for the poor, marginalized and vulnerable people in Uganda, which also had a chapter or a section dealing with access to justice for persons with disabilities, among others, and that report too confirms the limited access to justice for persons with disabilities in Uganda. These reports are available online. You can read them in greater detail to appreciate the limitations cut across, and we shall see some of the barriers. We'll talk about them later. Then what's the status of access to justice for women with disabilities? Two reports confirm that I looked at. That's last minute report again, affordability of access to justice for women in Uganda, and the affordability for lapse, legal aid service providers having to pay court fees. That report plus a feeder report study, feeder also conducted a study titled Access to Justice for Women and Girls with Disabilities in Arua, Kampala, Moroto district. And both reports speak to the fact or confirm too that there is very low level of access to justice for women with disabilities. And this is attributed to the low levels of education that most of the women have compared to the male counterparts. Low levels of income amongst women and women generally, and then women with disabilities, it's worse. And then gender prejudices, we talked about the stigma, attitudinal barriers that emerge from our service providers, like in the video that we watched, a police officer, asking for 450,000 shillings from a woman with disabilities, and also requiring, questioning the reason why the woman with disabilities would actually want to even report somebody who has had intimate relations with her and is not providing. And then poverty generally, because of the low levels of income, low levels of education, also inhibits the ability of women with disabilities to be able to access justice. So those are some of the reasons that are stated in those two reports. Now, that was generally really just a background or introduction. Now, how about the legal frameworks? Group Green did a good job in trying to identify the legal frameworks. We shall look at them here briefly, looking at the international the regional, the sub-regional, and then the national legal framework. Yes. At the international level, we have what is commonly referred to as the Bill of Rights. The Bill of Rights include the Universal Declaration of Human Rights, that is the UDHR, the International Convention on Civil and Political Rights, and then the International Convention on Economic, Social, and Cultural Rights. Those three instruments are what we usually refer to as the Bill of Rights. And when you read the two, the socio-economic, the International Covenant of Economic, Social, and Cultural Rights has more focus on economic, social, and cultural rights, issues like the right to health, non-discrimination of all persons in accessing healthcare, accessing work, accessing education, social protection services. Those are what, and therefore that means also persons with disabilities should be, government should ensure that persons with disabilities also access those rights. However, it has, because it has limited provision around the civil and political rights where our access to justice rights fall. So here we look at the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. And they provide for those rights. The UDHR, for one, reminds us that all human beings are born free in dignity and right, and that includes persons with disabilities. They too are human beings whose rights must be protected, promoted, fulfilled, and respected. There should be non-discrimination of all parties, all persons, including persons with disabilities. When you read these instruments, you will find that the provision that relates to non-discrimination lays a number of traditional grounds: gender, sex, socioeconomic standing, and then they may not state disability explicitly. Actually, the UDHR and the ICCPR, even the International Convention on Economic, Social, and Cultural Rights, don't have disability stated explicitly, but it states that on other grounds. And usually in our argument for protection of persons with disabilities, we say the open-ended provision in that instrument, which lists a number of grounds and says on other grounds, the other grounds include persons with disabilities. Remember, these are instruments drawn in 1966 after the Second World War, is it? So disability, the understanding of disability as a right had not yet been appreciated by the global village. And hence, we can go to the next. We can also look at the, hence the enactment or adoption of the UN Convention on the Rights of Persons with Disabilities that Group Green identified. In relation to children, we look at the United Nations Convention on Civil and Political Rights. Article 40 deals a lot with the right to due process, fair hearing for children in conflict with the law. So those of you who are handling children in your different institutions, you address your minds to Article 40 of the UNCR Convention on the Rights of the Child, on the provisions around right access to justice and the right to a fair hearing for children in conflict with the law. We also look at, and that may include children with disabilities. Actually, Article, there's Article 11 of the Convention on the Rights of Persons with Disabilities that deals with the language there is handicapped children, protecting the rights of handicapped children. Although using the word handicapped children is the old traditional terminology, but which we are moving away from because handicapcy is derogatory in its own, in the use of that, in the use of the word, and we can use preferably we use the words children with disabilities. They are protected under the CRC. We have the CEDAW, which is the Convention on Elimination of all forms of discrimination against women, and promotes non-discrimination and equality of all women against their male counterparts. Article 2 ensures effective protection of all women's rights and before any national tribunal or other institution. So picking from our video, the CEDAW would also be very important because these are women going to seek health services, and then the health services are not being provided. The attitude of the health personnel, the services, the beds are not user-friendly or disability-friendly. Therefore, they are being discriminated. So the CEDAW would also come in. But also when you're dealing with other cases that rights of women with disabilities have been violated, then the CEDAW is important. Article 15 also becomes important, where women must be looked at as equal before the law and under the law, so that they are equally protected by the law, just like their male counterparts. So that is what we have from the CEDAW. Yes. And then next, we can look specifically at the United Nations Convention on the Rights of Persons with Disabilities. This one we have to place more emphasis here, because this is a convention that is now specific on persons with disabilities. But that is not to say that persons with disabilities do not enjoy the rights provided for in other conventions. We must always remember that they are human like the rest of other people who may not have disabilities, and though the provisions in the other instruments too apply to persons with disabilities. However, because of the growing need to recognize the rights of persons with disabilities, earlier on, Timothy spoke about the models of disabilities: a social model of disability, the charity model, medical model of disability, the functionality model of disability. When we speak our legal framework here, we also introduce the human rights model of disability, recognizing that disability is persons with disabilities are human beings. They enjoy their fundamental human rights and freedoms like all other persons who are not disabled. So who do not have a disability. So we have to ensure the state and all other non-state actors and individuals have to ensure that they promote and protect the rights of persons with disabilities, not as a matter of charity. And Timothy emphasized this in the morning. Not as a matter of charity, but as a matter of right. And when we look at the preamble to the CRPD was celebrated by people in the disability fraternity, the international community, and it was called a beacon of hope. Why a beacon of hope? A light of hope to the people living with disabilities in the world. Because remember, we are moving globally and even at a national level. We are moving from a point where persons with disabilities were marginalized from society, their rights were not observed, they were considered a curse, a bad omen to the community, and in some societies, they were actually killed for having a disability. So to have an instrument that specifically speaks to the rights of persons with disabilities was a paradigm shift in the international context. And then, and it's a celebrated instrument with very progressive provisions. Adopted in 2006, so it's recent, it's not as old as the 1966 Bill of Rights. And in its preamble, it calls on states and all actors, including you and I, to recognize that disability is an evolving concept, that disability results from the interaction between persons with impairment and attitudinal and environmental barriers that hinder their full and effective participation in society in an equal basis with others. And this was emphasized by Timothy also in the morning. We have a person may have an impairment, which is either visual impairment, hearing impairment, physical impairment. But the attitudinal and environmental barriers that they interface with then create the disability. The preamble goes on to say that recognizing also that discrimination against any person on the basis of disability is a violation of their inherent right and worth as human beings. So these persons with disabilities should not be discriminated against. When they go to hospitals, when they seek our legal services must be inclusive so that they also enjoy the realization, the right to realize access to justice in our context. Or if they go to seek health services, then they should be able to also be attended to with a positive mindset, with accessible facilities and services so that they enjoy that right. Okay. The preamble goes on to say that recognizing further the diversity of persons with disabilities, recognizing the need to promote and protect the rights of all persons with disabilities, including those that require intensive support. When they talk about those that require intensive support and all persons with disabilities, that means we must identify needs. What a person with what is a special need that a person with disability requires for that person to be able to realize their full potential and enjoy their rights. So even when clients come to our offices and they are clients with disabilities, we should try and have a conversation with them and establish what is their unique need that they may require to enable them, enable us serve them better and enable them also enjoy our services better. Or if it's going to be a court a court hearing, then what needs to be put in place? We have to bring it to the attention of the court. My client has such and such a disability, and therefore we need the court to accommodate such and such measure to enable my client effectively participate in this justice process and realize their effective their right to justice. Sometimes members in the disability fraternity who are visually challenged give the example of when you actually suffer, have to identify, you know, our identification parades. You've been maybe sexually abused by somebody, and you probably know the person by voice or by scent, because people with visual challenges also, I think God has a way of giving them their extra senses. So they always say, if the identification parade is only supposed to be a mechanism of seeing, you must be able to see the accused person in a lineup in a parade and choose. Then a person with a visual disability may fail to actually see. But if the person says, I know the person because I know the scent or I know the voice, this is a person who lives within my community, then our laws should be reformed in such a way that they adopt those alternative measures of evidence, adducing evidence or communication by persons with disabilities. So that can be an example of ensuring that persons with disabilities are granted also their special needs depending on what they have and the impairments that they suffer, in order to enable them effectively enjoy a right. And then we have the principles that are embedded within the CRPD. The CRPD has principles like respect for inherent dignity and individual autonomy of persons with disabilities, non-discrimination of persons with disabilities, full and effective participation of persons with disabilities in society. Those are some of the principles. There are about 6 principles laid out in the CRPD, but those are a few. And then I thought we also appreciate certain key terms that emerge from the CRPD. We have non-discrimination, clearly, and most of these terms are defined in the Convention on the Rights of Persons with Disabilities. And Timothy spoke to them also. Non-discrimination of persons with disabilities. Providing reasonable accommodation measures for persons with disabilities. In our workplaces, in our courtrooms, in the jail sector, the justice sector, we must provide ramps, we must provide alternative communication mechanisms, we must have institutional policies that embrace persons with disabilities who seek justice. Procedural accommodations. We must think through some of our legal processes, procedures in court, and amend where need be those that, in order to facilitate persons with disabilities to adduce evidence, to in the justice process, to be able to access information from the justice process, and to find the justice process more user-friendly from the very beginning, from police, from our own offices or legal aid service provision institutions. Universal designs, we must have equipment, infrastructure, universal design to enhance inclusion of persons with disabilities. Use of assistive devices in other countries, if you visit, they have so many assistive devices beyond the wheelchairs, beyond the hearing aids, which are disability specific. Persons with disabilities can use alternative assistive, even augmenting those that don't have voice. There's an instrument we were once shown at a conference in South Africa that is used to augment the voice of a person with disabilities who cannot speak or who has low speech. Then alternative communication modes, recognition of the legal capacity of persons with disabilities, and also emphasizing the right to independent living and community inclusion for persons with disabilities. They must be able, persons with disabilities must enjoy their right to independent living like the rest of us, making their decisions, not to live alone, but to exercise their autonomy in decision making when they want to exercise to bring an action against any person, when they want to have a child, not to say you are a person with disability, why are you having a child? Why do you want to have a child? Those are independent living aspects which persons without disabilities enjoy, to decide what they want to do for their lives. They must be supported. And then also to be part and parcel of the community and take part in the various community aspects. So those are some key aspects that emanate from the CRPD. However, looking at the CRPD, the article that is specific to access to justice is Article 13, which states that state parties shall ensure effective access to justice for persons with disabilities on an equal basis with others, including through the provision of procedural and age-appropriate accommodations in order to facilitate their effective role as direct or indirect participants, including as witnesses in all legal proceedings, or including at investigation and other preliminary stages. So all stages of the legal process must begin to become disability inclusive. At PILAC, next PIL, we have done trainings with the judiciary, we have done trainings with the police on disability rights to ensure that even the police begins to embrace inclusion of persons with disabilities in investigation, arrest, statement taking, and putting in place reasonable accommodation measures to support victims or survivors who are persons with disabilities, or even accused persons who are persons with disabilities must be supported so that they play an effect. There are different justice roles in the justice sector more effectively. What 13 also says the state must ensure effective access to justice for persons with disabilities. State parties shall promote appropriate training for those working in the field of administrative justice and administration of justice. I'm happy that FIDA has put us together here as people in the legal fraternity to at least receive some information about disability rights law and inclusion of persons with disabilities. And that is a contribution towards really 13.2, ensuring training of persons with justice actors in the administration of justice sector. Other related rights that are within that are related to access to justice that are within the CRPD include right to equality and non-discrimination in Article 5. Article 6 is the rights of women with disabilities and addressing the intersectionality of vulnerability. Somebody in group during the expectation, the survey, someone said they want to know the intersectionality between women with disabilities and gender issues and rights issues. So even the CRPD calls for recognition of the intersectionality of vulnerabilities of women. Somebody is a woman with disability, a woman with low income, a woman who has been sexually abused. All those are intersectionalities that create extreme vulnerability, and we must prepare to address, our systems must be able to address their needs. The right of children with disabilities is also provided for. The CRPD also calls for states to recognize legal capacity and individual autonomy of persons with disabilities before the law, that there are persons before the law who need to be protected by the law. They must be supported irrespective of the nature of disability. We must, in fact, when you read deeper into issues around legal capacity, they're talking about supported decision-making. We should recognize persons with disabilities as individuals who have a right before the law to be protected by the law, to exercise independence and legal autonomy, express their wills and preferences. And how are they going to do that? We must put mechanisms in place that do not substitute their legal autonomy, but rather supports their legal autonomy so that they're in position to speak to you as you speak, just like you speak to another person without a disability, to express what they want. If you ask, so what do you want us to do about this case? They should be supported to be able to express, I want to press charges against this person in a legal action. I want a mediation. I want us to just write a letter to this person. So it should be their self-expression supported and brought to the forefront, not someone else, maybe a caregiver, a parent, or a mother, or a father, or any other person substituting their will and preference. So that's the input of Article 12 in brief, recognizing legal capacity. Also, there's Article 15 that seeks to protect persons with disabilities against any forms of cruel, inhuman, and degrading treatment. When we talk about sexual violence, gender-based violence, those are things that cause cruel, inhuman, and degrading treatment on women and girls with disabilities, and yet the right is also protected, not just in our legislation, but also in the CRPD. So I think from here, we now go on to the regional instruments. Also there's the CRPD also provides for accessibility in Article 9, and accessibility is to enable, we have talked about that persons with disabilities access the services that are needed. I just thought through and said, how accessible is the ECMIS, this electronic court case information and management system for our litigants with disabilities. I have not focused. We need to interrogate it at some point. Yeah, is it accessible to litigants with disabilities who probably do not have a lawyer and need to bring their case before the court and so on and so forth. But accessibility is one of the key tenets of access to justice and provided for in the CRPD also. Okay, so the CRPD is a paradigm shift in disability discourse because it recognizes the specifically emphasizes the rights of persons with disabilities. And it says that it's entrenched, that it rejects the historically entrenched understanding of disability that deprives persons with disabilities of any means to exercise their will and preference, which in many countries had effectively resulted into persons with disabilities being excluded from the justice process and from legal safeguards because they were seen as bad omen and so on and so forth. But the CRPD now brings forward the need to see persons with disabilities from a human rights paradigm, that they are human beings and must be protected and their rights must be guaranteed and they must enjoy their rights as of right, not as of charity or any other reason. So some of the soft laws that we should also look at include the international principles and guidelines on access to justice for persons with disabilities, passed in 2020. It's detailed. It has about 13 principles laid out, all speaking to access to justice. So I would request that we all go back and download the instruments, the international principles and guidelines on access to justice, and read it in totality because it's soft law. The legal, the treaties we have looked at and our national laws have a stronger force of law, as you know, the discourse around soft laws, but they also lay very good guidelines for state or parties who seek to enforce access to justice for persons with disabilities. We looked at another soft law that also spoke specifically to women's rights to access justice is the CEDAW, the Convention on Elimination of All Forms of Discrimination Against Women, General Comment number 33, which is on women's rights. Justice actors accountable. So those are the instruments at the international level. Now at the regional level, the group identified the African Charter on Human and People's Rights. Yes, that is the mother instrument at the regional level. And there are provisions. It recognizes the right to non-discrimination of all persons. Fair hearing is provided for under the Charter. All the right to receive information, and we have talked at length. Persons with disabilities must also enjoy their right to receive in braille form, either sign language interpreters. You can have JAWS installed in the courts so that they are able to read their court documents and so on using that software called the JAWS or any other framework that a person needs. They are able to communicate, bringing alternative communication mechanisms for persons with disability devices, for persons with disabilities in the courtroom, in our legal practice, in our law firms, so that where a person with disabilities needs an assistive device to communicate, an alternative mode of communication, maybe by pointing picture. That this part of my body of rights to deal with the rights of persons with disabilities is Kyokuhaire and more versus the state of Gambia. It's available online. I'll request us all to read it because it's really a very comprehensive decision on the rights of persons with disabilities and institutionalization in Uganda, which is a similar context that we deal with here. also in our SEHAD, and relied on by the courts in our own context. At the time, they were dealing with the issues that were arising from the SEHAD legal decision. So we have the African Charter. With respect to women's rights, we also have the protocol to the African Charter on the rights of women. On the rights of women, commonly known as the Maputo Protocol. You also look at it because it calls for elimination of discrimination against women. It mirrors the CEDAW at an international level. Women's rights to inherent dignity is also provided for them. And specific to persons with disabilities, women with disabilities, under Article 23 of the Maputo Protocol says protection. The states must ensure protection of women with disabilities from abuse, violence, discrimination, and the right to be treated with dignity. So that is as the provision within the Maputo Protocol specific to women with disabilities. And if you have a woman who has been sexually abused or a girl, and the Maputo Protocol also applies to girls. When you read the interpretation section of the Maputo Protocol, the definition of women includes girls. So girls who are faced in forms of violence, the provisions of the Maputo Protocol can also be evoked in arguing their decision, their case. Then we have the African Charter on the Rights and Welfare of the Child. As the name goes, specific to children, provides for the rights to children with disabilities under Article 13, protection of children against harmful practices, exploitation, sexual abuse. And then Article 17 looks at administration of juvenile justice and due process of the law when dealing with children. And this applies to all children. There's work I do with Naburu Remand Home, and we found some, I think some children with disabilities also there who were in conflict with the law, juveniles in conflict with the law. So the courts must also be, or even we as legal practitioners must equip ourselves with the relevant knowledge of the legal framework that protects such a child, a juvenile child with a disability in conflict with the law, to ensure that there is expeditious hearing of their matter. And even when sentenced to stay in the remand home is disability friendly in terms of its accessibility and the services that are provided there to protect the rights of such a juvenile. Newly ratified by Uganda, and this is really celebrated with because from my interaction with Ministry of Gender, they say this protocol, the protocol to the African Charter on the Human and People's Rights on the rights of persons with disabilities. It was enacted or adopted by the African Commission in 2018, but Uganda ratified it in November 2023, which is a plus. And the protocol is largely, in a large sense, is similar to the UNCRPD. And the protocol in its preamble there states, notes that they are concerned that persons with disability continue to experience human rights violations, systemic discrimination, social exclusion, prejudices within political, social, and economic sphere. So those are the reasons that led to also the passing of the African Regional Protocol. And in short, I call it the African Disability Protocol. But it's a protocol to the African Charter on the Rights of Persons with Disabilities. And we thank Uganda for finally ratifying that protocol and therefore demonstrating more serious government commitment towards protection of the rights of persons with disabilities in Uganda. And we are all enjoined to enforce the rights provided for in that protocol, which includes also access to justice. The protocol provides for freedom from non-discrimination, equality before the law, at liberty and security of persons with disabilities, protects persons with disabilities from torture, cruel, inhuman, and degrading treatment. And I think Article 13 or 15 also provides for access to justice, just like the CRPD. The protocol also recognizes states to enjoins the states, including Uganda, to take measures to ensure persons with disabilities access justice. And different from the CRD, it provides for ensuring procedural age and gender appropriate accommodations. Our protocol here adds even gender, which was not there in the CRPD. So because they know gender dimensions in the context of our African society are grave, and because of gender, if you do not take a woman maybe and give them camera proceedings. They may fail to adduce what? To adduce evidence in the courtroom. So gender appropriate accommodations are also needed. And then if you're dealing with a woman with a disability, then steps to ensure that customary law processes are inclusive and should not be used to deny persons with disabilities access to appropriate and effective justice. Then the training of law enforcement officers and judicial personnel, and states are also obligated to ensure legal assistance and legal aid, provision of legal aid services to persons with disabilities. So Uganda is on the right track when we talk about the adoption or development of the National Legal Aid Bill, because the state has a duty to also ensure legal aid service provision. And all other CSOs like FIDA, PILA, LastNet, and all of us acting in the legal aid service arena actually applauded for the efforts around enhancing access to justice for persons with disabilities. So this brings us now to the national context. At our national level, Green observed or recognized the availability of the Constitution. Yes, the 1995 Constitution as amended under Objective 16, the National Objective and Directive Principles of State Policy 16, states categorically explicitly that society and the state shall recognize the rights of persons with disabilities to respect and human dignity. Society is me, you, and all other persons. The state, you're well aware. So you see, we're already duty bound to observe the rights of persons with disabilities. Then Article 20 is inherent right of all persons with disabilities, which must be protected and observed by state, non-state actors, and individuals. And all those other provisions in our constitution, which I know you are more familiar with, like 21, 28, 42, 44, on the right to fair hearing and justice for all, due process of the law for all. So, and with respect to persons with disabilities in particular, you can look at Article 35 of our constitution, which is specific to persons with disabilities, and it calls on, it states persons with disabilities have a right to respect human dignity, and the state and society shall take all appropriate measures to ensure that they realize their full mental and physical potential. And that is what we are, what we are doing today is preparing ourselves to better serve persons with disabilities who interface with us in the legal sector, to realize their full potential and their rights and enjoy mental and physical health in its entirety. Parliament is called upon to pass law to protect persons with disabilities, and like Green noted, yes, they have passed such laws, like the Equal Opportunities Commission Act that we're going to look at, the Persons with Disabilities Act 2020, and we are going to look at those. I cited there Sehan Yiga versus the Attorney General, Pohit and Mo versus the Gambia, to really also demonstrate that courts are equally awake in trying, our Ugandan courts, in trying to protect the rights of persons with disabilities. So I request that we all go back and read Sehan Yiga versus the Attorney General. That is the part of the decision in that case, is the one that declared the use of derogatory language unconstitutional when it comes to persons with disabilities. And that case also interrogated the provisions of the MCA and the ITA of what ministerial orders, detaining persons with disabilities, pending ministerial orders. So we have to also go back and read those provisions in totality when we look at those cases. The Persons with Disabilities Act 2020 under Section 15 provides for access to justice, information, and training. Government shall promote the development, training, and use of sign language, tactile interpretation in all public institutions and at all government functions. Then the use of information assistive devices and technology. Provision of braille of public information, training of judicial officers and law enforcement officers. So you see, we have, the state has got a duty to actually embrace inclusive communication methods or tools or strategies to enhance communication for persons and access to information for persons with disabilities in all public sphere. And that also includes our courts and police stations and all the jail sectors. They must have people in place who can read tactile or communicate with a person with disabilities in tactile, sign language interpreters, brails. Imagine you receive a charge sheet, the person is visually challenged, has received the charge sheet in Word typed, and the charge sheet has not been brailled. How are they supposed to know the charges against them? So we have to move a step further in enabling persons with disabilities to access information. You can look at other relevant sections, Section 3 of the Persons with Disabilities Act, which reiterates the fact that all rights and freedoms enshrined in the international instruments of CRPD are to be enjoyed by the persons with disabilities in Uganda. Then Section 10 on accessibility of buildings, all buildings, and we already have 2 cases that have challenged the state on provision of accessibility of buildings and the public buildings and facilities. We have the legal aid, LAPID, legal aid of legal action for persons with disabilities versus Makerere University and KCCA. Then we have Chandia Emmanuel versus the Attorney General, very recent decision of Chandia Emmanuel. Of the Constitution also speaks to affirmative action for vulnerable groups, which include persons with disability. We also have another law which was also recently adopted, reformed from the Mental Health Act of 1964, treatment. Now we have the we were having the Mental Treatment Act. Now the new law is the Mental Health Act 2019. Specific to persons with mental health, in the act they are referred to as persons with mental health illnesses. But broadly, I like to refer to persons with mental disabilities. You have Section 3 that recognizes that persons with mental disabilities must enjoy all rights enshrined in our Constitution. And then Section 50 and the other instruments, like all other persons. Then Section 52, recognizing the right to dignity and respect of persons with mental disabilities. Then Section 60 is also very important, inclusion in our law, recognition of the legal capacity of persons with disabilities. And this mirrors Article 12 of the CRPD, recognition of the legal capacity of persons with disabilities to run their own affairs, make their own decisions, and we should be supporting them in that regard. This section has also been discussed a bit in Chiwanuka versus Chiwanuka. You go back and look at that case. Chiwanuka and Chiwanuka versus Chiwanuka. Kavali Benon versus the Attorney General. That's the case before the Uganda, which was decided by the Uganda Human Rights Commission, where Mr. Kavali's rights were violated by the police when he was arrested under the provision of then wrong and vagabond, etc. And then because he could not communicate and his conduct anyway, he was under one of those, he suffers with a mental health disability. So he was under one of his, what do they call it? Mental health lapse moments. He was arrested, beaten by the police, etc. So he then files a case before the Uganda Human Rights Commission, and the Human Rights Commission actually awarded him compensation for the conduct of the police. So you can, Chiwanuka versus Chiwanuka is a property rights case where that is popular. Mr. Morgan Chiwanuka suing his father, Chiwanuka, to be found to be a person with mental disabilities so that the courts can award Morgan Chiwanuka rights and orders to run over, to manage the property of his father. That's another detailed case. So we are beginning to see many more cases coming up in the courts around the rights, the property rights of persons with mental disabilities. And yet now our instrument, the Mental Health Act, is very clear and really has detailed provision on the rights of persons with disabilities to manage their own property, mental disabilities to manage their own property. Where they are unable to manage their property, they can appoint. They themselves, having been supported and their legal capacity recognized, they are supported to appoint personal assistants for their property. And court or the mental health board only comes in to appoint a personal representative where the person with mental disabilities has failed or is unable to appoint a personal assistant to help them with the management of their property. So at least we appreciate the fact that our law is now recognizing the fact that persons with mental disabilities can actually own property and their property rights should be protected, because we are coming from a society where their right to property was even disenfranchised once they have a mental disability. People, their family members will take away their property. So the Mental Health Act is also a good provision. Then you can look at other laws like the Domestic Violence Act, the Prohibition and Prevention of Torture Act, the Children's Act as amended has key provisions also around protection of the rights of children with disabilities. Domestic violence, I indicate that because many persons with disabilities also suffer various forms of violence within or abuse within the domestic sphere, their own families, because of the prejudices, the stigma, the attitudinal barriers, people locking them up and beating them up, unable to even attain education. Some families, they're even not fed because they want them to die. So the Domestic Violence Act can come into play. In some families, children with disabilities are being sexually abused by even family members, and sexual violence is one of the forms of violence that is provided for in the Domestic Violence Act. Yes. And then the policies. Green identified the national policy on persons with disabilities. Yes, it has been revised. We have an old policy 2006, but now it has been revised to 2023, which is a commendable effort for the state. And in the policy, strategy 2, priority area 2 of the policy, first of all, seeks to protect persons with disabilities against abuse, neglect, and exploitation. And the strategies that are to be embarked on in order to achieve that priority area is one, enhance, among others, is to enhance communication in different formats, Braille, sign language, to report, investigate, mitigate, and eliminate discrimination-based, disability-based discrimination and abuse. Then strategy 4 is to enhance counseling and psychosocial support to persons with disabilities and their caretakers. And our women and girls who may face any form of abuse, sex and gender-based abuse, will no doubt need a lot of support in terms of counseling and psychosocial support in order to recover from that such an ordeal. Then we have the policy, the National Children's Policy 2020, which recognizes also the need to protect children with disabilities against abuse and violation. All these policies are available online. Members can also download them and appreciate them in totality. Then the draft legal aid policy. It's important that we actually tighten our belts as a state in enacting and adopting the draft legal aid policy and the act in order to provide legal aid services to these marginalized groups of people. Okay, I thought maybe we can identify some court cases to really show that the judiciary is also not sleeping. They are awake to the need to protect the rights of persons with disabilities, and so should ask the legal practitioners now, because if we don't take these cases before the judiciary, if we do not argue these cases and present them, the judiciary will not have work, the bench will not have work. So Bushoborozi is available versus Uganda, who was incarcerated for a long time with stalled proceedings under these ministerial orders in line with the provisions under the Trial and Indictment Act. And then we have Justice Batema saying there was a violation of his right to expeditious justice by causing his detention for a very long period of time awaiting ministerial orders. So Justice Batema was very vehement in saying that there is need to actually reform those provisions of the Trial and Indictment Act that allows for ministerial orders, and thereby persons with mental disabilities get lost in the justice system, in the whole system, because nobody resurrects their cases before the courts and so on, and then their right to expeditious justice is violated. Morgan Tuwanuka, we've talked about it. LLPD is accessibility, and the judiciary has been really employed a lot of judicial activism in upholding these cases. Chandia Emmanuel and accessibility of the court premises. Sehad Liga, we have talked about that. Sehad, Perez, Moase, and 2 others versus the local government. Perez was a child with autism whose parents failed to access health services for him from an old age. When they diagnosed him with, they noticed he must have had a problem, and then now he lives with that disability. He lives with autism at this moment. So Sehad and 2 others, Perez's relatives, brought the action against the local government because they are the health facility where Sehad Perez lived, and the Attorney General for failure of the state to provide health care to children with autism. And indeed, the judiciary was very eloquent in holding the state liable and finding that the state was in violation of the right to health for persons with disabilities, and then for children with disabilities by failing to provide the services that they needed in the health centers to provide for children with autism, etc. Then you have Uganda versus Ndroma Pasco, where Justice Mubiru sentences a person who raped a child with a disability to 12 years imprisonment. It was aggravated defilement, and then you see, this is a child below age, a child with a disability, and then the child is raped. All those compounded vulnerabilities. So because of that, Justice Mubiru was also very stern in providing at least 12 years and I think 4 months of imprisonment to the perpetrator. Uganda versus Tessimana Rosemary, also that was delayed justice because she was detained for a very long period of time, police with nothing happening on her case. So when the matter came up to court, Justice Golantene noted that there was actually a violation of Article 126 of the Constitution on Expeditious Justice, etc. Yeah, so we applaud the court's judicial activism and work around disability rights. So the next aspect would be to really look at the disability, the efforts of the Disability Coalition. This is the coalition some years back, that is NETFIL. The coalition, the members were NETFIL, that's Network of Public Interest Lawyers, then of the School of PILAC, School of Law, Makerere University, NODIPO, and the East African Center for Disability Policy. We had a grant, we got together, and in a bid to really promote access to justice for the rights of persons with disabilities, we developed the draft, what we call the draft judicature High Court rules on handling matters involving persons with disabilities in our courts in Uganda. So the rationale or the reasoning behind these rules was really to present to the judiciary some framework of what needs to be done by the judiciary in order to improve access to justice for persons with disabilities and make the judicial system or the court system and the infrastructure also disability friendly. So these are proposed rules. Right now they are before the Rules Committee of the Judiciary. They are analyzing them. The last time, about 3 months ago, the rules were being discussed by the Ministry of Gender, Labour and Social Development before they can be finalized and adopted by the Rules Committee of the Judiciary. So I believe that once adopted, we may get a version that is different from what we have now, but the spirit may not change of how courts can go about improving access to justice for persons with disabilities. So the rules, the draft rules touch on accessibility of court premises, and some of these issues takes its total speed at adopting these rules. We decided as NETFIL to begin challenging some of these practices by court jurisprudence, develop court jurisprudence around it. That is why we have Chandia Emmanuel's case that also came up. Because the rules provide for accessibility of court premises, the right to provide documents, court documents in any form, in different types, right, brailles, or to accept even sign language interpreters in the court in order to enhance access to information for persons with disabilities. The rules provide for reasonable accommodation mechanisms depending on the different types of disabilities that clients come with before the courts. The courts should be open and aggressive to providing reasonable accommodation mechanisms. The rules speak to dealing with the persons with mental disabilities in the courts. If a person comes to the courts and the court realizes that the person has a mental challenge, should the court just dismiss the case? Wisdom, defer, stabilized, and court can get guidance from medical practitioners on the status, the mental health status of this litigant, and then when the litigant can be able to appear before court and continue with the proceedings before the court. So the rules, the draft rules are detailed in terms of the processes that the courts can put in place to protect the rights of persons, litigants who come before the court with a mental disability, and how the court can break down or anything and how the courts can handle. Then the determination of disability, how can the courts determine disability? Is it a judicial officer's mandate, or there should be a medical practitioner should be called into the courtroom to determine the disability, and also the person with disability allowed to express their need, their accommodation measure in light of the disability. The rules also have detailed provisions around relating to criminal matters, considerations for bail, for instance, if a person has a disability, because the bail proceedings right now don't have disability as one of the grounds for a judge to exercise their discretion in granting bail. So the rules also propose a reform to include disability, and also where bail is not granted, how disability friendly are the detention facilities, the prisons, the police, even the police units. By the way, we have to think even from our police ourselves, how disability friendly are they to receive an accused person with disability who is on remand, or who is at the police, and the police cells and has not been awarded bond. Then issues around recording of statements, the trial process, committal plea taking. A person with disability, the judicial officer must ensure that a person with disability was clearly explained to the importance of plea taking, and is given all the communication tools to ensure that they understand the charge against them and they are able to take their plea also effectively. Even plea bargaining, as a person with the accused with disability is being given the necessary support for them to undertake or be part of a plea bargaining process. We have a colleague who has done a study around the plea bargaining, critiquing the plea bargaining strategy, and one of her findings or argument is that the plea bargaining is also creating injustice, because litigants don't understand, they just want to get done with the lengthy criminal processes. So you find accused persons are just accepting the charges against them, even when they have defenses, but because they want to get out of the criminal justice system faster, they then take this plea bargain. But what does it also mean now for an accused person with a disability who may have a communication challenge? Are they really appreciating the plea bargaining? Are they really playing effective part in these plea bargaining processes? Then at committal, when people take their plea at committal, the judicial officer, the magisterial area should be able to note on the file that is being transferred to the High Court at committal that this accused person or the victims in this case have victims with a disability, or the accused person is a person with disabilities, so that the High Court also prepares to accommodate such persons before the courts. And then the draft rules also have provisions around the role persons with disabilities can play at the point of as witnesses, how they can be facilitated to be witnesses in the court. If you look at the Evidence Act, I think the Evidence Act has the language of a person with hearing impairment. I've forgotten, but there's some limitation from the Evidence Act, those who can adduce evidence. And persons with disabilities are kind of excluded from providing evidence. So these draft rules, we are trying to cure that problem, to say the courts need to put in place mechanisms that also allow persons with disabilities to adduce evidence or play the role of witness in the court, in the courtroom. And also when sentencing decisions, disability can be taken as one of the grounds at the point of sentencing in the courts. And the rules also provide for accommodation measures during when the court is hearing civil matters. So I will share the rules with Lynette, the draft rules with FIDA, so that if you have time or if they have your email, the FIDA team will be able to share with you also those draft rules so that you read them in detail. We have already shared them with the judiciary. We have done judicial trainings around these rules. First of all, with the judiciary holistically on inclusion of persons with disabilities in the courts. And also we discussed these rules at length with the judicial officers who participated in the training. They made their input into the rules and so on. We look forward to the final rules that will be adopted by the courts, the rules committee of the court. And when they are finally adopted and you see these new practices emerging in the courtroom, that will only call for we as legal practitioners also to style up and do what needs to be done in terms of supporting our clients who come to us with disabilities. So that is what the draft rules are about. Yeah. Yeah, so some barriers to accessing justice for our clients is, of course, no reasonable or procedural accommodations in the courtroom. We have talked about that. Lack of assistive devices or alternative communication modes in the courtroom. Presence of the informal justice system, because the informal justice system is less technical, less costly, available within the community. So you find that most litigants end up in the informal justice system because they are not even trusting that our formal justice system, as legal practitioners that we are, will embrace them or include them in the provision of our services. Then the language barrier also does exist. Limited knowledge of the law among the litigants, attitudinal barriers and social stigma, absence of shelter homes to safeguard and provide protection to litigants, victims, survivors who may need protection. We don't have government-run shelter homes. Most of the shelter homes in the country are run by CSOs like Uganet, like UONet, Action Aid, but they are also challenged with limited resources. So some of them are even closing. Corruption in the judicial sector, that one we shall not talk anymore, but everywhere, even now, Parliament. Yes. So location of these court structures, we all know distance and so on. Inaccessible general sectors, of course, the litigation. Of course, although I know the judiciary is trying hard to ensure that there are courthouses at every region or district and then the sub-county level. And now we are happy that there are many more magisterial areas that are gazetted by the CJ just last week or early this week. And that is all in a bid to enhance access to justice for the people. And we hope that it works out. Lengthy court processes may also affect our litigants with disabilities because they may have psychosocial needs, support, and when the processes are lengthy. So as judicial officers or lawyers, if we keep adjourning matters and so on, and not being prepared and ensuring expeditious justice, we actually affect the litigants with disabilities even more than those without disabilities. Then limited family ties, some of them need support to be able to enforce their rights in the jail sector, but if they don't have the family support to come with them, walk with them to the police station, bring them, like somebody's visually challenged or so on. Earlier on, Timothy was talking about crossing the zebra crossing. You're thinking, how am I going to Wanega police? Are visually challenged. There are so many cars, the street lights. They are not talking street lights. In some countries, street lights talk. So that those with visual challenges know that it's green, like a now cross and so on. But in Uganda, our street lights don't have that kind of thing. So even the white kids are not respected by many road users, all those challenges. Then lack of the recognition of legal capacity. Those are some of the barriers that inhibit access to justice for our litigants. I think we can go to the next, in the interest of time. The next. Then what would the solutions then be? We need a responsive justice system. We need legal players. All actors must have expeditious justice and trial processes. Enhance knowledge of the law among women with disabilities or all persons with disabilities. We need people like sign language interpreters, alternative communication mechanisms or modes utilized by the courts. Strengthen community services and sentencing guidelines, because instead of incarcerating people with disabilities, when we know that our detention facilities are not disability friendly anyway, although then we may use other modes like community, what is it called? What is this, when the judicial officer says somebody will do this kind of work? Sentencing, community service, or suspended sentences, depending on the nature and gravity of the offense also. Yeah. Then infrastructure improvement. Then we also need to pass the legal aid bill and the policy so that as a state, we also embark on providing or supporting the provision of legal aid services. Yes, please. Yeah, so those are some of the solutions. Yeah. Reduce adjournments, strengthen alternative dispute resolution mechanisms between parties. Right from I know most legal aid service providers use a lot of ADR really in order to avert their litigants or clients from the lengthy court processes. And that would really work for our persons with disabilities, depending on the nature of the case, of course, because if they are criminal matters, then they have to really go through the judicial process. And but then that means we do all we can to ensure that it's expeditious. Then training of all justice actors on the laws on persons with disabilities and their rights. So those are some of the solutions we speak to. Can carry. I got some quote from one Robert McClellan saying an effective justice system must be accessible to all, must be accessible in all its parts. Without this, the system risks losing its relevance and the respect for community it serves. Accessibility is about more than the ease of access to sandstone buildings or getting legal advice. It involves an appreciation and understanding of the needs of those who require the assistance of the legal system. It includes components of rule of law and democracy influencing. So that I think is important to ensure that our justice system is all embracing. So as legal practitioners, as I went down, I implore you to recall that we have a duty under the UDHR to ensure that all persons with disabilities are human rights with dignity, whose rights need to be protected and upheld by us. Yeah, you can dig them out and look them further. So thank you very much. I hope that are still present. No one has jumped ship. Thank you very much for listening. I hope it has been useful. And when we learn about those laws, then the strategies that we're implementing and enforcing the rights of persons with disabilities. Because some cases may need public interest litigation, others need legal aid services. Other strategies, other instances, we can use advocacy, research and advocacy. So our advocacy is empirical based. We must embark on moving a model for legislative advocacy, policy reform, collaboration. Collaborating with partners cannot be underscored because we need referral pathways. Clients need a variety of services. Sometimes we are providing only legal and providing yes, the staff, the employees, and capacity building. We have talked about training the justice actors, all that is important, and then creating awareness about disability rights, laws, responsibilities on all duty bearers. So thank you very much. That brings us to the end of this session.
Dr. Patricia. Thank you very much. And in a way that that will really stick with us. So we appreciate you for that. And so we are scheduled to take a 30-minute break after Dr. Patricia's session. But I know many of our participants are part of the FIDA team, and we do have a webinar on the FGVB coming up this afternoon. And so my proposal is perhaps we forego the long break and we just do like a 5-minute break, and then we go to the last session of the day so that we can finish in around 2 or closer to. And so that those who wish to attend the webinar can do so. And so unless there is a strong objection against that, and perhaps we can just take 5 minutes and see people have held peace. And so let's reconvene in 5 minutes from now. And yeah, thank you everyone for your participation and attention.
I hope they want legal food.
Welcome back, everyone. And I hope you've also had an opportunity to grab something quick to eat, as we have done here in the boardroom. And so we are now moving into our third and last session of the day. And that will be led by Mr. Thomas Kyokuhaire. And we'll look at, it will look at practicalities around safeguarding the rights of persons with disabilities and within organizational context. And as we have come to expect of Thomas as a facilitator, we are sure the session will also be very practical and something that we can really apply. And as we run our own organizations on legal practice, and then as we work with people with disabilities in our various spheres. And so Thomas, back to you, and we are looking forward to this final session of the day.
Okay, thank you so much, Lynette. Good afternoon, everyone. I hope you are still there and energetic. No, this session is not going to be informative like the one of Patricia. This session is going to be more reflective. We want to reflect on what is going on. Where I sit at a community level, there's this perception that GBV, rather abuse of women and girls, is on the rise, is increasing. But on the other side, we know there are a lot of work being done by almost a number of organizations and people. Kyokuhaire is priding itself for 30 years of existence, of doing good works, but still on the surface, when we read papers, when we interact with community members, when we watch TV, like the video that was shared, those are the stories. Those are the same issues. So the question is going to be, so the question we have is asking ourselves whether our current approaches are deep enough, or is there something that we are still missing? And like as I said, there is no thesis that has been written on this. There is no paper that has been written. So it's going to be more of a reflective session. And my role is just going to be asking questions like I've asked on this. When we look back, is there something that we've not done yet properly yet or deep enough yet to make sure? Because when you look at the legal provisions, like Patricia's taken through, you'd realize that we are covered. When you look at the service providers, they are available. When we look at their commitment, it is there, but still the abuse is going on. And one person, if we're looking at that, would say is on the rise. So first of all, what are some of the drivers? Are we saying that there is motivation for financial gain from both the abusers and the abused, the victims? Is it in search of influence, reputation, or increasing profile? Is that what is increasing gender-based violence? Is understanding or appreciating abuses a problem? Because when you, one of the studies we did, we found that actually there was a lot of abuse going on, especially among women and girls with disabilities, but they were not aware that those were abuses. They thought it was a favor to them. Like, I mean, if I took you out and bought you a beer and then abused you, for them they'd look at that as an opportunity. On the part of the abusers, they would look at this woman with a disability and think that they are only quote unquote assisting her by, falling in love with her. So are there opportunities for skilling or networks aptitudes that individuals have that is promoting the sophistication of abuse? Or is the emergence of cybercrime and improvement in technology putting across new opportunities for abuse. Because right now we know if people are abuse is being mobilized on internet or on phone. People are even removing evidence by these how do you call them, the messages that disappear immediately. It's open, so even if there was any attempt to follow up there are no tracks left behind. So really the question would be, what are the drivers that we are encountering? So therefore, for us as organizations, as service providers, we need to ask ourselves what we need to do from both the organization point of view, but also from the service provision point of view, or from the individual disability rights activists point of view. So the first consideration would be the statement of intent. When you look at, unfortunately, we didn't introduce ourselves so that we can get to know which organizations we are coming from, or which law firms we are coming from, or which spaces we occupy. But when you look back at wherever you sit, wherever you belong, and looked at the policy statement, is it disability inclusive? And if you do, is it known by all the stakeholders, or is it that you're doing some good work there, but the would-be users or beneficiaries of your service do not know about your commitment or your intention? Is it accessible? Is it in simple language? Is it, or when one checked on your website, can any person look at it? Is your website accessible for persons, for everyone? Is it interactive? So, or is it still that policy that is known by yourself, by your inner circle, but not known by the people that you're meant to serve? And of course, when we are starting, we would check around and say, persons, the women and girls who are abused, and would check with them that if you're abused, where would you go to seek support? You'd be amazed that most of the women and girls with disabilities were not aware of where to seek support. And yet we know that the service providers are available. When you look at the structure, when you look back at the structure within your organization, wherever you said, if I'm abused, be it a staff, be it a beneficiary, be it a stakeholder or a person that you come into contact with, can I identify a focal person whom I can whisper to that I'm being abused? Is that focal person supported and trained? Is that focal person motivated? When these things were, when the wind started, many organizations picked up the issue of appointing focal persons on safeguarding or in organizations. But you'd find that the person is not supported to understand the role, but the person is not supported by management or leadership to function properly. And even the focal persons were not being appraised. So in other words, they felt that that was an additional task, but the organizations had not gone beyond to put that function within the areas that the person is appraised against. So from the statement of intent, then we look at what is our commitment. Have we transited from policy to strategy? For instance, if you look back on your strategy, does your strategy speak to your policy? Can we identify some objectives or some actions or some guidance on how you want to implement the intention you have of protecting everyone. Like we saw in some of the legal instruments, there is that commitment that you as legal service providers, you don't discriminate. But do we see that in your strategy? Do we see it in your action plan, or do we see that? So in other words, there's that transition between the intention and the commitment, and that can be seen from the strategy. Then, for instance, if we checked, are there resources provided for safeguarding, or is it usually the use of emergency fund, or waiting for to be for allocation of resources just in case something happens? Or is it something that you made a commitment to, that yes, as for us this year, as this organization, we are committed to promoting safeguarding in this to protecting any woman or any girl that is abused, and therefore these are the resources in case that happens. Because in many organizations that we've interacted with, you find that yes, they have an intention, they have a will, but when it comes to resources, you find that they have to be given all excuses that you see the budget limitations, blah, blah, and that kind of thing. And yet we know that some of these abuses, they may not require the time that you require to process the support. For instance, if a person is raped, immediately that person needs to be rescued, and that person needs medical attention, that person needs, but when you go to organizations, yes, they have the policy, they have the focal people, but when it comes to availing the resources in that at that moment, with the agency, it requires, usually there are some challenges. Then the support, I've already talked about the support. I'm sure you've come across where abuses are being done, everything, the focal person is working, or even both medical and the legal support is being provided, but the support from leadership, from management is not forthcoming. We've read about a number of stories where people are being protected by their supervisors in the name of not protecting the reputation of the organization, or protecting the reputation of a person, that this person has had a very good career, but now you want to spoil his reputation and career. So that kind of support, is it forthcoming? Are we sure? If you started, for instance, investigating your supervisor, because even supervisors are abusers at some point, or is it possible that you can get support from peers or from colleagues for you to follow up that kind of thing? So here we are looking at whether safeguarding has become an accountability issue, not necessarily a policy issue. Accountability meaning that, for instance, when we have our meetings, for instance, if we checked the last board meeting of your organization, was getting feedback around safeguarding or GBV cases? Was it discussed? Is it among the items to be discussed? So those are some of the things that we need to check ourselves and ask, are we really committed? Because yes, we can have all these policies, we can have all the whatever, but when things are not being discussed and checking what has to be done, then we know we may still have some gaps. For instance, I talked about doing an analysis. For instance, if you checked in your system and you have one of your areas of intervention is SGBV, the question would be, do you give accountability of whether how many cases you've handled, or whether things are moving well, or or are you that person who has a call center, but you don't care whether the calls come in or don't come in, or whether they are drop calls that you don't, try to follow up, or, some of these things might look small, but they mean a lot when it comes to holding ourselves accountable. Yeah. Then from commitment, we move to culture and practice, because yes, we might have safeguarding or GV work around as a separate or as a standalone department or as a standalone activity, but the question would be, is it mainstreamed in all stages? Because abuse is in all spheres, yeah, at community level, at household level. When it comes to an agency like FIDA or any other organization, in all departments. So we wouldn't say because we have a department on SGBV or we have a manager on GBV, then we've done our part. The question would be, is it mainstreamed at all in all sectors and in all processes? For instance, when we are doing fundraising, many of our organizations stand on fundraising or on writing concepts, on writing proposals. So do we check whether we have considered safeguarding when we are doing the risk analysis of our proposals, of our work we are doing? And just an example, if you organize an activity of a legal aid clinic in Pasese, for instance, have you analyzed the kind of risks your trainees or the participants of your clinic would encounter? What are those risks? Have you put in place a strategy for mitigating some of the risks that they're encountering? And here, for instance, if, for instance, you organize the legal aid clinic and it went beyond 5 o'clock and this woman goes back home and is beaten or is denied this and that, would you take responsibility as the one who caused that? So those are some of the things that would be demonstrated whether our culture and practice are changing. When we look at our learning and reflection, most cases, most organizations have reflection meetings or learning sessions, but is GBV or is safeguarding one of the areas of reflection? Is everyone in your organization happy and comfortable with what is going on, or is it that you think everybody is empowered and therefore, since you have a system of reporting any abuse, therefore you are certain, but yet you need to find out whether that system that you put in place is working or whether it needs some improvements or some kind of learning from it. Then we look at partnerships. What kind of partnerships do we have? Yeah, as an organization, as people. Yes, we said we might be good as lawyers, but you may have some, but SGBV has a number of issues around it. And therefore, do you have any relationship with other service providers that are complementing legal aid or are complementing the services that you're providing? So partnerships, again, is a reflection of how you've moved from commitment, from intention to commitment, and now practically you're putting it into action through partnerships. The strategic alliances that you have, the strategic partnerships that you have, is a reflection of how you're going to deal with the SGBV more effectively. So again, this is something again to reflect on. There are 6 pillars. These are not standard pillars, but there could be more pillars, but I thought of the 6 that we could think about when we want to deepen the work we are doing when it comes to safeguarding. And in this case, meaning that we are not only thinking that we are safeguarding people who are out there, the ones that we work with, but also safeguarding even the people that we work with in our organizations, in our families, in our homes. Yeah. So the first one is safe culture. The other one is governance. We have safe people, we have programs, we have reporting and safe response, and we have communications as the 6 pillars. So when you look at safe culture, we would ask ourselves, for the safe culture, we would look at the culture and leadership. Is it diverse? Does it promote diversity? Does it embrace respect of people? Does it challenge inequality? Does it encourage staff to speak out if standards are not met? When you look back in your organization, or is it that you have to live by the rules or by what is set down? But as long as we have we embrace diversity, or we treat people with respect, we challenge inequality, and encourage staff to speak out, then we at least we have a positive culture. Are the partners and commitments aware of what we expect, or how to hold them accountable? In most cases, we don't work or we don't deal directly with the people that we provide our services to. Sometimes we work through paralegals, we work through community structures, we work through that. And once once they become part of your structure, then the community will hold them as though they are holding you accountable. So you find that a mistake made by a paralegal or a person who is at a community level, community legal volunteers, they may not fully understand what you stand for and yet misrepresent you or do the contrary. So again, we need to check whether in our culture, we don't stop at ourselves, but we ensure that partners and communities are aware of what we stand for and what they should expect us to do. For instance, if we went to a community that you're working in, does that community understand your code of conduct? Does it know that it is unacceptable for you, for instance, to get a bribe? Is it that they will assume that, or you assume that they already know? So again, these are some of the things that we portray, whether we have a safe culture or a culture that promotes safeguarding in ourselves, but also in our organizations. When we look at governance, again, here we are looking at the board and senior management. Sometimes we've come across where the code of conduct and everything is only applicable to the junior staff, is only applicable to the others, but not me, the chief executive, or the senior or member of the board. So, but where we are looking at governance that promotes safeguarding, we are looking at whether the board and senior management itself has that level of accountability when it comes to safeguarding in their language, in their behavior, in their practice, in what they do. So in other words, the practice trickles down. When we look at the procedures of managing risk and addressing gaps, are they well documented? Do we have a way of knowing that this is done well and this is not done well? Or is it that every case is handled as it comes as the organization is run? Do we evaluate our practices? Do we evaluate our policies? For instance, what kind of learning have we done from the implementation of the previous year? For instance, the previous year we said we have a call center, but from the kind of feedback we've been receiving, we realized that a call center alone is where people are using voice is not reaching everybody. Have we modified make it, that it cannot have a facility for a text message or a WhatsApp or something? Because now we know those are some of the changes. That's how we felt that those are some of the changes that management has supported for us to make those adjustments. When you look at safe people, I'm sure you all do this, but just for this, when we are doing the recruitments, are there standards that we follow? Do we do safety checks in place? Are using reference check referees effective? How come that we've received a positive reference check and 1 year down the road, the person is contrary to what was written in the reference? Sometimes we ask letters of good conduct from Interpol, from where, and we get this positive whatever. Do we have a mechanism of keep trying to check whether that there is compliance, or there is people are changing behaviors, or is it because I got a good reference at the entry, then that means I'm a good person all through and through? Or because I got a letter of good contact from Interpol, and therefore you think I'm an angel? So, but we need to keep checking and supporting people to keep safe. Our staff and people work with clear about their responsibilities. We keep updating them on the support that we provide. Are they adhering to policies and the code of conduct? What are the issues that they are raising? Because these abuses are coming from the same people we entrust to protect the vulnerable. Yeah. If for just imagine you are working in a community, and there's that power imbalance between you and the community, and you're here trying to pretend that you're supporting this. And this slide and this kind of information, I think would be more meaningful, I hope so, if we are speaking to a male-dominated kind of audience. Yeah, but you never know, even some females could be abusing fellow women. So, which is against the code of conduct. So when you look at safe programs, again, this is where we make a lot of mistakes and where we don't have a lot of control. But we need to check ourselves whether the programs we develop, the activities that we are developing are within the national and local context. So again, so that we are relevant, we are not introducing things that are alien, that we identify potentialists for different groups in the communities and plan for them. Yeah. Again, the risks in terms of, we usually give this example of where a technical person cites a borehole in a certain distant place, and young girls go there to fetch water, and then they get abused from there. So the question would be, is a problem of the abusers, or is it you also the person citing the borehole part of the problem? So again, or the person who is organizing a meeting in a hotel but has not checked or about the safety of the participants, or the person who is organizing an activity is not mindful of the time that people have to cover when going back home, and in the process they are abused. So again, this is the kind of risks we need to check when planning programs. Again, some of the programs we need to specifically look at whether they safeguard children and women and girls and the communities generally when we are doing that. Then there's a whole issue of the partners and service providers that we work with. Do we assess them? Do we assess the potential risk they pose, or is it because they are not part of us, we think we are not responsible? But I think when it comes to this, we take responsibility of the partners and service providers that we entrust part of the work we are doing. So about self-reporting, I've already talked about this. We all have complaints and reporting mechanisms where people report. We have toll-free lines. We have all these communication regarding where they need to seek support. But the question is it accessible? Why is it not being used? Why is it, is it accessible by all sections of people, children, partners, staff? Is it known by everyone? When you change, do you go back to change the communication? Or then when it comes to investigations of the abuses, we are talking about sensitivity here and appropriateness. Again, Patricia talked about it, how we do the interrogation of the victims, the kind of languages we use, the kind of environment we put them to get information, sometimes might even cause more harm. Yeah. At an organization level, is if you say, if you are abused, please go and report to your supervisor. What happens if it is the supervisor abusing me? Or what happens if I don't trust the people who are involved in that? So all those need to be checked when we are trying to deliver a good safeguarding program. When it comes to whistleblowers or people giving information, what kind of protections do they have? Because sometimes people fear to report because of the fear of the consequences that come with the reporting. So again, that needs to be clear. When it comes to communication, we have a lot of media and communication activities. So we need to check whether we have incorporated safeguarding in there. For instance, is the kind of media we are using. We talked about it. Some use radio, some use TV, others use print, posters, flyers, and the rest. But the question is it reaching everybody? Or is it? We've also seen where people are using communication in a in forms that are disrespectful. When it comes to rural women, then they are putting them to portray the inferior role or when it comes to persons with disabilities, they are playing a role that is on a receptive, or, when it comes to, so that kind of communication also needs to be checked. Otherwise, it might send wrong signals. When it comes to, again, information that we get, the data, the images we are taking, sometimes we forget to seek consent, or sometimes we are not aware that we need to seek consent, not because we have smartphones that you can quickly take my photo, or take my voice, record my voice, or take a video without that consent. And what we've seen in most cases, especially the people who are abused, especially for those who are working in NGOs, there's this business of demonstrating visibility. So you want to take a photo with the victims or the survivors of abuse. So the question would be, how are you going to use that photo that you've taken, or that information? You've collected a lot of information from the survivors, their location, their telephone contacts, the village where they are staying, the house numbers, and the rest. So supposing the abusers come across this information, what happens? Are you taking that responsibility? We've attended meetings where we sign on attendance sheets, and they're asking your contact and your disability type. We came across a situation where some of the abusers, there are some disability categories that are deemed to be weak. So therefore, the rapists and the other abusers try to target those groups. Like, for instance, many people think that by having a relationship with an albino, it cures HIV/AIDS, or by raping a deaf woman, that woman can't give evidence in court. So therefore, it is a shortcut. So if you don't communicate, if you don't have a proper way of managing this information, then you're likely to even cause more harm to the people that you're working with, other than protecting them. So, but we've also seen instances where people give consent, and yet others refuse that consent to be withdrawn, and yet it is within their legal rights to withdraw that consent. Again, the dignity of the people of the photos and portrayals that we make to the people we work with. I'm sure you've come across people taking photos, and they put them on the cover page of a young child, with a torn pair of shorts, when and maybe with the running nose, with the flies around the nose, and they put such a photo on the cover page of their strategic plan or their annual report or whatever. So and in most cases, they want to show that, to use that for raising funds. Again, that is the dignity that we are talking about, that persons with disabilities have been abused more when it comes to developing communication. And in most cases, they've also been left out from accessing the services we provide, because our communication is not well thought about. But also the communication has exposed them even more to abuse, if we are not a bit cautious. So that is regarding the checking whether our safeguarding is deep enough. Otherwise, from what we see, that the cases are increasing. Persons with disabilities are 10 times more likely to be abused than women and girls without disabilities. And the services that we provide, like we've been discussing since morning, are not accessible to persons with disabilities, and therefore we need to check ourselves and ask, what do we need to do? Do we need to revise how we are doing this, or do we think that a miracle will happen and therefore one day abuses will certainly stop and people will get justice out of the work we do? Thank you so much. And so any additions, because like as I said, this is not informative, but it's interactive. And therefore we expect that you share experiences from the kind of work you're doing and what you think needs to be done for us to improve work around GBV in this country. Any questions? Any comments?
Yeah. Yes, so just to reiterate, this is the opportunity to share reflections and really on our overall framework on really what we can do better. And I know we have fewer participants, far fewer than what we started with, but I also know those who are with us in the room and have some real experiences and some real stories and also some real questions. So this is an opportunity for reflection, for conversation. And I did mention this earlier, but also if you have really particular practical questions about how to overcome some of the challenges you're facing in your own work, specifically when it comes to working with persons with disabilities and providing a real inclusive legal aid service, this would be a good space to discuss some of these issues and perhaps find some solutions together. All right, so Thomas, it seems that we do not really have further reflections or further questions. Patricia, would you like to share reflections, perhaps, if you have any? Yes, and we had that. Let me just say one. Okay, something from Patricia.
Yeah, thank you very much, Timothy, for that very comprehensive discussion around safeguarding. Actually, listening to you, I was actually thinking about what we do at the faculty in ourselves and realize that we are probably limited in strategic intervention. That said, I thought looking at the issue of data, even some things that I do not think about, the registers that we always have at meetings, how to ensure that they are protected and people's identity is protected so that you do not expose them to any further abuse, and the principles around data protection. It just got me thinking about the provisions of the Data Protection Act as well. We have Data Protection Act, which was enacted in Uganda. And if you, the reading of the act, which is very important, because sometimes we get people's information and just share without thinking twice. And yet that Data Protection Act now seeks to protect that kind of information that you get from a person. You're not allowed to share private information without the consent of that particular person. And if you need to share it, then you should actually get a court order and so on. So I think data storage, protection, and thinking about the safety of our clients is very important, even our employees. Sometimes you find personnel file just lying around, and yet that can create a lot of discontentment and conflict. The information contained therein, another employee can pick it up and becomes a source of discontentment or conflict within the organization to the extent that it can put another person at risk. So I think those those pillars you express even our programs. You know, when you give that example about when you're scheduling a program and the program is going to run till 5 weeks, have you thought about the participants? How are they going to get home? Will they be safe when they get home? And how will their most times husbands react when they get home later? And how have you protected them against any abuse or violation that may come with that? I never really stretched my mind that far when programming, but today you got me there, and I actually started thinking, maybe recall a colleague of mine would always tell her when we have office retreats. You know, we are always so excited when we have office retreats. Oh, office retreat for 3 days. Oh, we are happy to pick up bags. But often she would refuse. She would not come alone. She would always have this and that excuse. But one time when I sat and talked to her, you know, closely, and she confided, she opened up to me. I remember she told me, you see, I have to, if there is an office retreat or something like that, I have to share the invitation letter with my husband. And then I have to deal with issues of him asking who is going to make my bed, who is going to cook my food, because I don't eat food prepared by a house help. If you're not here, I'll not make the bed for even 4 days. You see, those are gender roles that then tie somebody, and got me realizing, oh, so this is why she actually feels it's difficult for her to come for these retreats, because she's balancing between family safety or needs and so on, and the work needs, and she can't just tell everybody about it. You really need to get so close for her to be able to open up. And these are things sometimes we don't really think about. We can even label an employee uncooperative or disinterested in other extracurricular activities of work, without thinking that maybe that employee is actually dealing with a bigger challenge at hand that we are not opening our eyes to. I recall actually when we went for a dinner, an office dinner one time, and we just said, okay, let's just have an office dinner which will end around 9 p.m., 10 p.m. Her husband was actually around. She came, you know, she had not told him he's coming. It's different when you know somebody's coming and to pick you up and maybe be part of the process. But when you just realize, oh, somebody's around and is acting like a spy around me, you know, it creates difficulty. So thank you very much for those pillars of safeguarding that you have shared, and kept our minds open to the fact that they apply both to our clients and even staff. And we must protect data that we have. We must have office policies, safeguarding policies. We must have maybe some forum where a person who is feeling a threat, or a client who is a threat, maybe by an employee, acts as a mechanism for reporting and addressing the situation. Yeah, so thank you for those pointers.
Any other reflections from our remaining participants before we close? Yeah, Dr. Patricia, thank you also for reflection.
Yeah, Lynette, just one more comment. You see, when it comes to abuse, there are those categories of people that we don't usually think that they need to be protected, or we have a responsibility. And just quickly, if you can run, if you can check with whoever is on the call and has a baby and has not put that baby on her status, or whether that person actually checked with the baby, whether that baby likes to be on her status, you'll be amazed. Yeah, and the practical question would be, if these people who are kidnapping children got to your status and found that you have a baby and the photo, everything of your baby, and they look for that baby when coming from school, track that baby, don't you think that you are the one who caused that problem with your communication when you're not aware? So we have a colleague who had such a problem because she was good at updating her status with her baby, and then this guy kept on tracking the baby from school and then getting the picture right, correct. So again, to me, safeguarding shouldn't only be limited to gender-based violence, but also it's not only about sexual relations, or this, a conflict between husband and wife, but also the safeguarding in this case should be able to cover staff, the family members, but also the reputation of the organization. Because if anything goes wrong in an organization by any one of the staff, then that means the entire staff. I'm sure you recall a story how the judiciary was going to have a problem. I don't know how it ended, where the senior people in the judiciary were abusing their colleagues, and then they were protecting the person, so that kind of thing. So the point I'm making is that the abuse is not only the persons with disabilities, or it's not only the weak, but even the powerful sometimes can be abused, but even those that without a voice, like the children, it is our responsibility to protect them using the 6 pillars as well.
That's some real material for reflection. And and I must say, I don't think it has ever occurred to me you need your child's consent to use, to use their photos on your status. But that is something to really think about. And also, we also have really seen what you're saying, that it can also be people in power, even that can be quite vulnerable to abuse. And specifically when it comes to election season, or previous election season was mostly done online, and women suffered abuse. Women who are powerful, women who stand for public office, who really have a strong career behind them, but yet they are victimized. And I think online avenues make that even easier for to stretch the scope of who is vulnerable, because it really is people at all spheres of life that can be vulnerable in one way or another. Is there any other reflection, any other response from our online team, or online participants, I should say? Oh, Agnes, I see you have a hand up. We'd be very happy to
Thank you so much, Thomas and Dr. Patricia. I've learned a lot from this session, and the fact that I'm so much interested in disability rights and inclusion. This has been really a learning lesson. Any gaps that I've been having, this has been really good. There's also an aspect maybe I can bring forward that I've gotten from Mr. Thomas's last submission, the vulnerability aspect, which also affects our clients. Some of our clients come to the legal aid clinic and they're well dressed, they're driving good cars. This woman looks good, but then at the end of the day, when she sits down and talks to you, an aspect of vulnerability comes in, and an aspect of power authority. The power aspect also comes in. So that means you have to look out for extra bits of how this woman is suffering at the end of the day, and how you can help them without looking at their outlook or what they're wearing or what they're driving and how much money they have. Vulnerability is very, very important, because all of us at a certain point we are vulnerable, and especially women with disabilities and girls with disabilities. Thank you so much.
Thank you so much, Aggie. We appreciate that reflection. And so as we close up, please take a look at and be sure to complete the post-training evaluation, which you will find in the chat. And I've put it in the chat. So please be sure. I see many of us have completed the pre-training evaluation. And I'm sure that those who are attending the training and for purposes of also earning CLE points will see it out towards the end. So please do be sure to complete the post-training evaluation. You'll see there's a repeat of most of the questions as we want to see if there's any change in your perceptions and your knowledge from before and after the training. And so at this point, unless there is another comment, another reflection from the team, I would like to take the opportunity to say a very, very big thank you to our excellent facilitators. Patricia, we are really, really grateful for your time, your preparation, your expertise, and for always saying yes when we ask you and bringing your best. Thank you for always doing that for us and for really building the movement and being part of the academy in such a meaningful way. And also to you, Thomas, we are really grateful to your expertise, to your practical approach, and to the journey you've walked with us over the years, and to expand our own awareness of what disability inclusion means and the steps we have taken and we continue to take. We really acknowledge your role in that. So thank you also for the training and for our participants, and especially those who are still here. And we know that this is quite a long training, but we do appreciate that you are able to be with us until the end, and that you've not missed any part of this. And so please take note that we will have our next training in July, and it will be on really environmental justice from a gender perspective. And to be led by Dr. Nathan Google, who is the ED of Kyokuhaire in Kenya. But we will be advertising about that CLE training in due course. So please take note of our socials and the groups that you may be part of. Otherwise, I wish you a very, very lovely afternoon and a lovely weekend. And we hope to see you again next time. Thank you. It's a It's like butterflies.
We're done, eh?